Yeah,
Very nice. Very good. Good morning, Your Excellency. This is day 2, and we'll be starting with the claimant's witnesses. We have Miss Atala in the box, and so she will need to be sworn in, as the first thing. Stand, please.
Hello, yes. I swear by the Almighty God to tell the truth, the whole truth, and nothing but the truth.
And Your Excellency, we have an assistant who will be helping the witnesses find the page, and that is all. Ms. Atala, could you please just state your full name for the court?
Patricia Atala.
Okay, there's no need to be quite so close to the microphone.
Okay.
That's all right.
All right.
But it's good to keep your voice up, and that's
Okay.
so everyone can hear you. Thank you. You should have a bundle of witness statements in front of you.
Yes, I do.
And if you could turn, please, to tab 1, which is page 298. I have page numbers at the top right-hand corner.
Yes.
So page 298, please.
Right.
Is that a copy of your second witness statement?
Yes, it is.
And if you could turn to the end of that statement, please, could you take a look at page 316?
Yes.
Can you confirm that that's your signature?
Yes, that's my signature.
And then you need to go to tab 4, please, on page 390, 390. Take your time, that's fine. Give her some help to find the page, please.
390.
Thank you.
Yes.
Yes, and do you see there a copy of your third witness statement?
Yes.
And if you turn to the back of that statement, see page 403, 403?
Yes.
And can you confirm that that is your signature?
Yes, that's my signature.
Thank you. And then the last one, it should be the last document in the bundle. It's tab 6, page 425.
Okay.
And can you confirm that that's your fourth witness statement?
Yes, it is.
And then if we go to the end of that, page 427, you see there your signature?
Yes, that's my signature.
Thank you. And can you confirm that the contents of those 3 witness statements are true to the best of your knowledge and belief?
Yes, I confirm they're true to the best of my knowledge and belief.
Thank you very much. If you wait there, there'll be some questions for you.
Good morning, Mr. Atala. You are the Chief Legal Counsel of the GLOBEMED Group.
Yes, I am.
And prior to that, you were the Internal Legal Counsel of the GLOBEMED Group. You have been with GLOBEMED almost all of your career, haven't you?
Almost, yes.
Insofar as you deal with subsidiaries, you would tend to work with local counsel, wouldn't you?
I would.
And that's true in the UAE, isn't it? You would work with local counsel here.
Yes.
Just tell us who those local counsel are.
Current local councils?
During the events that are an issue in these proceedings.
Started here back in 2007. We've had changes all throughout. I don't recall the names of all of them. There was at some point Ziad Saloom, Fadi Sarkis. Others.
Well, let's start, if I may, with the time when GMGHS was being incorporated. Do you remember who was the local counsel at that point in time?
Yes, I think it was Lebanese lawyer, OMAN, yes.
I want you to talk my friend said you may need to be a bit closer to the microphone.
Closer? Yeah, sorry.
Could I ask you to turn to page D401, or could I ask? Oh, great. Thank you. You look at paragraph 36 at the bottom of that page, and if I read the second sentence, while I was not directly involved in discussions pertaining to the HAD license, I refer, for example, to the following documents, which I have been shown for the purposes of preparing this witness statement. So you are dealing with documents relating to the HAAD license. You weren't involved in those discussions, were you?
No, I was involved, but I have a team with me. The legal team is not just me, I have a few lawyers as well. So the teams with me work more in details, and I follow up a bit high level.
So in terms of what you mean by not directly involved, you were involved at a higher level?
Yes, more or less, yes.
And the people who were directly involved, as you put it, would have been your legal team?
Right, and the lawyers on the ground here, following up with them, yes.
So in your high-level indirect role, were you shown the various emails to which you refer in that paragraph, and indeed the PSRs, the progress status reports, to which reference is made in that paragraph?
I see these.
If you look at little a, b, c, and d, documents are identified. Look at the first, for example. Let me ask the question, give you the opportunity to answer. Were you shown these documents at the time?
Yes, of course. Again, on high level.
So, for example, if you look at the PSR at page 3625, sorry, this is the covering email by which it was sent. It wasn't sent to you, was it?
No, I wasn't copied on it, yes.
Are you saying it was then shown to you by someone?
Yes, that was back in 2015. I was involved on high level. The team was following up. So I must have seen it, me or one of my team members, and with a forward or copied on further emails related to it, yes.
Why wouldn't you have been copied on this email?
Because that was practically, as I see, it was a project status update. It was very technical. It was between the Dubai team and the OIC team.
It's not a document that was intended for you?
At the time, no.
If we look at F33653, this again is a week later. It's the covering email for another PSR, as I'm going to refer to them. This wasn't sent to you, was it?
Mr. Reid, would it be possible to give me the reference?
Sorry.
So I can follow up.
Sorry, 3653, my lord. My lord, would it assist if someone was...
Well, the problem, the way how it works today is that I think I have to go through the e-bundle rather than what we did last time. But we'll see how
it may even help you to have someone with helping you with the e-bundle. Maybe we consider that one.
Yeah, we should have 3 screens in this case. But we'll see how it goes. But thank you.
But this is a week later. This is 14th of May. This is a further PSR. And again, you're not copied, are you? It's not sent to you, and you're not copied to this email. If these PSRs had been sent to you, they would have been alarming, wouldn't they? These PSRs would have been alarming, wouldn't they, if you had seen these PSRs?
They're not mainly legal, so if it's not purely legal, I wouldn't be worrying about the whole part of it.
We look at 3672, please. These are Mr. Tomey's comments on the 14th of May PSR. And again, if we look at the top,
There's no, the list
sorry,
of
we
the...
may need to go up. This email was never sent or copied to you, was it?
No.
And if we look at 3759, again, this is an email from Mr. Tomey. Now, he's on the GLOBEMED side, isn't he? He's on your side of this transaction.
Correct.
And if he felt something needed to be seen by you, he would have sent it to you, wouldn't he, or copied it to you?
Sometimes forwards things later, yes. But we were not copied.
Now, you say in your statement that I've been shown these documents for the purposes of preparing this reply witness statement. And you then quote selectively from those emails. Your evidence, isn't it? You have been shown a series of emails for the purpose of highlighting certain sections in emails which were never sent or copied to you.
These were later forwarded because they had the tripartite contract. If you see in the email of Elitami point 2, it's related to the tripartite agreement.
Let's go back.
Don't interrupt the witness.
Well, I need to have a document. It would assist the witness.
Just listen to her answer first.
Can we go back to 3759?
I'm on the screen. That's the screen. So it's point 2, tripartite agreement with providers. It says, as for the correspondence I've seen today, there are 1 or 2 pending items with our legal department. I have communicated to both of them, and Amran, that should be finalized tomorrow and draft transferred to OIC for your legal team's review. So it had legal implications or discussions within them, whether on the had license or the agreements. So these were later transferred to us and to the team, me or one of my team members, for follow-up and for handling.
He's saying he's communicated with the legal team, which is you,
Yes.
but he hasn't copied this email to you, has he?
No, that's an email he's speaking to the client. Their communications would be internal.
Your evidence is that the commercial team, if I can call it that, Mr. Tomey's team, re-forwarding emails to you after they've sent and copied them to others.
Those of relation to us, yes.
GMGHS, as I understand it, had an offshore predecessor. Is that right?
Correct.
And GLOBEMED Gulf Free Zone, the predecessor, had been offering services, TPA services in the UAE since 2008. Is that right?
Correct.
And if we could look at D346. Could focus on the table. This is Mr. Saliba's statement, just to give it some context. If one looks at the number of insured lives in the left-hand column in that table, the number rises briefly to 24,000, but then diminishes by 2014 to 1,800. It's fair to say that GLOBEMED Gulf Free Zone had not been successful.
No, because GLOBEMED Gulf Free Zone, when it was first incorporated, we had a reinsurance company as a partner. There was Swiss Re, and it was a partner, and they stayed for around 3 years maybe until there was a change in their strategy to leave the Middle East. They left the Middle East, and that impacted, as the partner impacted GLOBEMED. That's one. And the second reason is because the operating model of GLOBEMED was a bit different, and it was hard for GLOBEMED to apply an exclusive operating model in the UAE, given that the market was working on non-exclusive basis. that impacted the results of GlobeMed Gulf. Free zone, that is.
Your business model was dependent on exclusivity,
Correct.
whereas your sense of the local market was that TPAs were acting non-exclusively.
Correct.
That made it difficult for GlobeMed to penetrate the UAE market, TPA market.
This is one of the reasons. The second was the departure of the previous reinsurance partner.
Had you agreed exclusivity with the previous reinsurance partner?
Reinsurer would not be a client, but it would bring in its clients on reinsurance basis, yes.
But your dealings with them or your transaction with them didn't prevent you from offering TPA services to other insurers, did it? Your relationship with the reinsurer, as we call
Yes.
it, did not prevent you from dealing with other insurers, did it?
No, it did not.
I think the reinsurer you have in mind may be Swiss Re, is that right? And can you confirm when Swiss Re left the UAE market?
I'm not sure. Probably they stayed on board 2-3 years, something in that region. 2011, maybe.
2011.
Um,
In fact, it was after Swiss Re left the UAE that the real decline in the number of lives occurred.
Yes, from the numbers, it seems, yes, coincided as well.
So the first reason you cited for that decline is probably not the reason for the decline from 24,000 to 1,800, is it? You cited, when I pointed out the decline, you gave two reasons, the first of which was the relationship with Swiss Re.
Right,
But we've established that relationship had ended by 2011,
almost.
almost. And insofar as the significant decline from 24,000 to 1.8 thousand occurred from 2011 to 2014, that decline was probably not caused by the relationship with Swiss Re.
It was probably caused by two reasons, the relationship with Swiss Re and the non-exclusivity, the exclusivity that we, GlobeMed, tried to impose on the clients and didn't go well with the market. Given that GlobeMed uses this model across the 12 operations it operates, so it exists in other territories, PSA, Kuwait, Bahrain, Palestine, Jordan. Everywhere we use the exclusivity model, yes.
If I jump forward, after there was a DHA ruling in 2018, wasn't there? And after that, GM Gulf Free Zone has only been able to offer medical billing services.
After when?
2018, sorry, I apologize for jumping forward.
In 2018.
From 2018.
Right.
It is the case that the Free Zone company has only been able to offer.
Before 2018. The change in the object when we incorporated GlobeMed Gulf, I think 2 years, there are 1 or 2 years before 2018. Or I think it was in 2014. The Free Zone company became engaged mainly in RCM services, revenue cycle management services.
Can I just take you quickly to 391, sorry, D 391, just so we can clear this up.
Yes.
So you refer to regulatory changes and you say as a result of those, the Free Zone company is no longer permitted to provide TPA services and had to amend its license activities. Then you attach an application, you attach a copy of the current trade license of GMG, which the Free Zone entity, which is now called QuantMed. Then you say that provides an explanation of the distinct type of services permitted to be undertaken pursuant to both license categories as follows. First of the medical billing services. But that suggests in exhibiting the DHCA ruling on permitted activities 2018, that that's part of the regulatory background, which in effect that the free zone company can now only provide medical billing services.
Right, before 2018.
May come back to that. Now, you, as I understand things, had overseen the establishment of GHS in 2013. Is that right?
Right, GMGHS, yes.
And you had seen it established as an onshore entity in order to deal essentially with the regulatory requirements. And to be clear, that was long before GlobeMed was pursuing Oman, wasn't it?
Incorporated in October. We got the trade license in November of 2014. We started discussions with OIC in June, so that was basically 6 months apart.
So October, November 2013, and the initial discussions with Oman OIC are June 2014.
The NDA was signed on June, yes.
So the NDA is a convenient starting point, a way of seeing whether discussions started, in fact.
It started mainly in August. That was when I was first copied on emails, but the NDA was signed as early as June.
Now, GlobeMed and its shareholders needed a UA national to be the majority shareholder, didn't they?
Yes, this was a requirement, yes.
That wasn't a requirement that you took very seriously, was it?
I don't understand.
Well, you thought that that requirement could, in effect, be sidestepped by the use of a side agreement, didn't you?
Sorry, can you raise your voice,
Sorry.
please? May I please ask you to raise your voice?
Insofar as it was a requirement for a national partner,
Okay.
you thought that could be avoided by the use of a side agreement.
No. No, not as per se as you stated. No, that wasn't the intention.
What was the intention of the side agreement?
So the law requires the setup of a company locally onshore. We sought legal advice, local legal advice on the incorporation. And one of the requirements was the bylaws and the shareholding. And Adil Hello was chosen as the shareholder, being recommended by one of the trusted friends of the group. And there was good friendly relationship between him and some of our shareholders.
Who was the trusted friend who recommended Mr. L.L.C?
I don't know. It was someone, I think it's the same Khawand person. I think that was him. Khawand, that's the Lebanese person who lives here, works in Beirut, works in UAE.
Can we look at the side agreement? If we just look first at the Arabic 1507. I take it that the Arabic is the original. Confirm that?
Yes.
And that's why we see the signatures on page 1550. And it was notarized in the Dubai courts, wasn't it?
Oh.
Okay, if I'm looking at page...
This is the side agreement?
Can we clarify this?
I go with the numbers. I made a mistake, sorry. Sorry, had the wrong reference. I apologize. Can we go to 1512?
That's the side agreement.
Oh, that is the side agreement.
Right.
And if we go up a page? Did you sign this agreement at any point, or did you add your initials? Can
Are not there.
you just confirm who has signed it?
First, the first party is Adil Hello. Second, third, and fourth, it's Farid Ahwaji. He was signing by proxy on behalf of the second, third, and fourth party. There's first witness, Hadi Maroon Khawand. Second witness, Haifa Matar Sidawi.
Can we go to the English?
So to interrupt, there is a middle sign for Adil.
One diagonally across the page.
Probably he couldn't add his name. I don't know. I wasn't signed.
He's within your company. He's like,
Adil Hello, unfortunately, passed away.
but sorry to interrupt, but what's the reason he's signing this document? Just to one of other shareholders?
Malord is the national partner.
Yeah, but he's the
No,
first.
yes, I agree. There's another Adil who signed.
Yeah. I know, he's the first party.
Right, yes.
Signing twice, this is my turn. Anyway.
And the first signature next to the first party, he didn't write his name, he wrote it down.
Sorry for that, just one.
We could look at the English. This is obviously a translation, isn't it? Because the names have been garbled.
Page number.
Sorry, 1513. Now, if you look below the table, see there the percentages.
Yes.
I could just read it out. Whereas the shares are divided as per the company's memorandum of association, whereas it's a formal division which does not reflect the reality of the partnership between the parties. That is admitting that the company's memorandum, the false presentation of the ownership of the shares, isn't it?
Not a false presentation. The official one and the true one is the bylaws of the company or the memorandum of incorporation.
You say it's not the reality. Unreal.
I don't say that's not my drafting.
Whose drafting was this?
That was done by the local lawyer that was handling the thing.
Would have read this document, wouldn't you? You would have appreciated that the company's memorandum did not reflect the reality.
Did not reflect this, but it was a reality, yes.
This is the reality, isn't it?
So, the memorandum of incorporation is the reality. That was, okay, I'll explain. This agreement was signed because it's not a difference in reality, but there was the official percentage, which was in the memorandum of incorporation. That was the real percentage. But here there's a difference because the GlobeMed Limited was the one that funded all the capital of the company.
Sorry to go back, Mr. Tuller, but it says the company's memorandum, whereas it's a formal division which does not reflect the reality of partnership among the parties. That is saying in terms that the company's memorandum does not reflect the reality.
It does not reflect the memorandum. Yes, these are different than the memorandum of incorporation.
Talking of the memorandum and saying it doesn't reflect the reality.
Saying what it's saying, but the reality is they are different. This is different in percentages than the percentages of the memorandum of incorporation.
We turn on to page 1514. Look at Article 4. First party undertakes to cooperate in order to obtain licenses, permits, necessary visas for the company. Is maintaining a pretense that Mr. Hellu would be providing services, isn't it?
No, Mr. Hellu was providing services. He signed letters on behalf of the company. He sent rent contracts. He visited officials, and whenever we had issues, I remember once we went together to the Ministry of Health. We had issue over a contract. I got his approval before filing this case. He was involved and brought up to speed. He was the only one of the shareholders present in the UAE. The rest were in Beirut. So on the ground, his name was on the trade license. I used to commute back and forth between Beirut and Dubai, and I used to meet with him and discuss the issues on high level, of course. He wasn't involved in the operational at all.
Sorry, he was involved at a high level, or you were involved at a high level?
I used to brief him on the high level. In this case, in particular, I got his approval before filing the case, just as the rest of the shareholders.
When he undertakes to cooperate in terms of obtaining licenses and permits?
Yes, he used to do that. He used to travel to Abu Dhabi for the renewal of the licenses. He was the only one officially on the ground. It was his name on the trade license. None of the other shareholders were present in UAE.
Well, there is a significant body of correspondence in respect of licenses and permits, GMGHS. I'd suggest to you that he's not involved in correspondence relating to licenses and permits.
He's not involved by emails, yes. We used to communicate with him mainly by phone. There were the people that were on the ground. They used to talk to him. I used to speak to him a lot over WhatsApp. I have contracts that's signed by him. We have letters to Ministry of Health on contract-related matters signed by him.
You're saying insofar as you were dealing with him on licenses and permits, those communications would be by phone or WhatsApp?
Yes, because we would involve him when things became a bit more complicated or needed help. So whenever it was simple, the juniors on the ground, the operational people would handle. But when things required presence of an official or a company representative with signatory authorities, or we needed support with the local authorities, we would request his help, yes.
We look at Article 10 at page 1515.
Yes, Adil was not involved in the funding of the company and did not want the risks. GlobeMed as a TPA requires a lot of funding, spends years investing and paying money before it becomes profitable. So he didn't want the risks of having to fund the company or be involved in the losses. And against this, he wasn't taking the profits. But there is at the bottom, in the second line, if you at the bottom line of Article 10, it says, if he then decides to take the profits, he would have to pay 150 AED.
Sorry, which line are you looking at? I'm
So it says if the first party, third line at the end of Article 10, if the first party does not fulfill this obligation for any reason, then it shall pay to the first party an amount equivalent to triple the latest fees paid to the first party.
that's not
His
profit.
fees are 50,000. He would have paid 150 if he then opted to take the profits.
That's not a profit. That's a penalty for a failure by OIC to pay him his salary, essentially, isn't it?
No, it's not a penalty. He had the ability because the first party undertakes to assign its profits in the company exclusively to the second party against obtaining a lump sum of AED 50,000. If the first party does not fulfill this obligation for any reason, it shall pay the first party, that's supposed to be, sorry, the second party, an amount equivalent to triple the latest fees paid to the first party. So he would pay 150 and
Mr. Tyler,
if he-
I appreciate why you're trying to do this, but the penalty for not paying the 50,000 dirham cannot be described as profit.
No, can we go to the original Arabic version? I think there's an error in the reference to the first party here. Reference, please.
That should be 1510, shouldn't it? Asher, so bottom of 1509. Under Al-Asher.
15.
1509.
Yes, there's an error in the translation. In Arabic, it says, and I quote, if I may, Your Excellency, may I speak in Arabic?
When I've translated, yeah, translated.
Yes, it's the same, but there's an error in the translation.
Yeah, it's already noted in the hearing today, but deal with it in different way. This has been translated by the claimant, or
There is an error.
who translated this? Who translated this document?
I don't know, I'm afraid. I'll find out. It's probably my document, so I will check.
I understand it's the claimant's document.
Yeah,
I agree. If there's an error of translation, we can deal with. We'll come back to that after.
yeah, we
after
should come
lunch.
back to this later on or submit fresh translation.
As I understand it, this is the contemporaneous translation, so it hasn't been formally translated for the purposes of the court proceedings. There were two documents that were produced, one in the Arabic, one in the English. That's where it comes from. I think between the parties we can figure
Right.
In any event, you would have been aware, Mr. Tuller, that a local partner could not waive profit.
That's UAE local laws. I wouldn't be. I can't say that I would have known.
You would have discussed with the local lawyer why this side agreement was necessary, wouldn't you?
That was initially the agreement between Adil Hello and the shareholders when they met here in the UAE. And the reason was, I told you, the funding was made fully by GLOBEMED Limited. None of the other shareholders actually participated in the funding. And he didn't want any risks in neither risks or losses.
Well, he was giving up a share of profit, wasn't he?
He was giving up.
Giving up any share of the profit.
This clause, yes.
And in discussing the need for a side agreement with the local lawyers, you would have discussed why the side agreement was there, wouldn't you?
That was part of the incorporation process. Because Adil did not want to be involved in the losses, and because GLOBEMED Limited was providing the funding.
I put it to you that you were aware that under UA law, a shareholder could not assign or waive their profit.
I'm not a UAE lawyer, I'm a Lebanese lawyer. I haven't worked in the UAE, so I'm not aware.
You would have been
Why I have legal advice. We have local legal advice.
Well, you would have discussed with those local lawyers why it was necessary to put a side agreement in place, wouldn't you?
Yes. Yes, this was discussed. And it was necessary because the shareholders were not paying the capital. The shareholders, the GLOBEMED Limited was funding the company.
Sorry to interrupt. When you say the shareholders, all of them, they didn't contribute, or just
Yes, none
Mr.
of them
Hadi?
contributed.
All of them.
The whole capital was provided by GLOBEMED Limited.
You needed a side agreement by which the real share ownership was made clear and by which Mr. Hello waived his profits.
Yes, against fees for avoiding the risks of losses. But then again, he would have claimed he would have been able to take the profits, but he would have to pay 150,000.
You're not trying to tell me that the 150,000 is by way of profit, are you?
Again,
Are you seriously suggesting that the 150,000 dirham is a share in profit?
no, it's not a share in profit. He would have been able, if the clause says he waives his share in profit against 50,000, but if he doesn't do it and he takes the profits, he will have to pay 150,000 if he opted to take the profits. That's what the clause says.
Can I just clarify this? The 150,000, is that clarify 50% of 300,000 dirhams being the capital limit for the LLC? Why it is 150? Why is not 200?
It was 3 times his fees. So his fees were 50. He would have to pay 3 times his latest fees. So if this was used after 2 or 3 years and his fees were, the 50 became 100, the 3 times would become 300. So it
Makes sense. Just my mind goes to a different area where it's a LLC company under the UAE and has to be as a limited capital is 300,000 dirham.
no, I don't think that was the capital of the company.
the way
It was
how-
higher, I guess. There was a requirement because the TPA was a regulated business. We had a higher threshold for capital.
I'm sorry for that. Just
No.
about-
Thank you.
You move to page 1525. We look at Article 24.
Page number? Are we in the same page?
Oh, sorry, I'm trying to get to Article 24 in the side agreement. I may have got a misreference. I apologise. Sorry, 1518.
One 1518, I think.
1.5?
18.
It says here, halfway down the page, second paragraph of Article 24, hereby understood and agreed the first party was appointed as a citizen partner, as is required for the incorporation of the company inside the UAE by virtue of Federal Law 8 of 1984, not as an actual partner in the company. Again, you were aware that he was not a real or an actual partner, weren't you?
Yes, because he wasn't willing to participate in the losses, yes.
Driver of needing the side agreement was that you didn't want him to be participating in the profit, did you?
The driver of the side agreement is for all of them being, all of the shareholders on the side agreement, none of them was funding the company. None of them was providing the capital. And yes, it was for Adil Hello to provide that he will be taking a fixed fee and not participating in the profits and losses and funding.
Well, it was to make clear that he was not an actual partner in the company, wasn't it? What it says.
Yes.
You were aware that it was seeking to comply with the Federal Law 8 of 1984. It was a formal compliance.
I don't know the laws. That was drafted by the lawyer. I cannot say what that law was and what's inside this. I don't know.
Remarkable lack of curiosity for a lawyer, isn't it? Not to be curious as to what the relevant requirement is.
Incorporation requirement, I assume. That's the
You assumed it was an
documents.
incorporation requirement.
Because it's the incorporation documents, yes.
I suggest to you, Ms. Atala, that you knew full well, under the side agreement, he was not an actual partner. The purpose of this agreement was to make clear that he was not an actual partner and that he would have no share in the profits. Could we look at 1551? This is the company agreement, the memorandum, as it's been referred to. This was made on the 7th of October 2013, wasn't it?
Yes.
And that was the day after the side agreement, wasn't it? From your perspective, this was the same work stream, wasn't it?
Incorporation of the process of incorporation, yes.
You would have worked on the company agreement, wouldn't you?
That was also the lawyer. Of course, I must have seen it. Our standard, usually legal documents.
And it has the same parties as the Hello agreement, isn't it? Sorry, the side agreement. And would you accept that the terms of these agreements are flatly inconsistent?
A shareholder side agreement and this
Yes.
one, yes, there are differences between them, yes.
If we look at the agreement of incorporation, if we go down that agreement, look down. So, for example, 1553, the right of a shareholder to transfer shares subject to certain preemption rights. Now, the side agreement has made very clear that Mr. Hello didn't have that right, hadn't he?
The right to transfer, that was based on the shareholders agreement.
And if we look at 1557, bottom 13.2, profits shall be distributed, profit and loss, sorry, should be distributed among the partners as follows. And then if we scroll down, first party, that's Mr. Hello, 20%.
Profit and loss will be distributed among the
He didn't have a 20% share in the profit, did he?
company never made profits, so that was never put to test.
Never put to the test, but in terms of contractual entitlement, we've seen the side agreement. He has no entitlement to profit.
Correct. He took a specific fee, but he would have been able to claim profits against paying 3 times his fixed fee. But the company never made profits. Were questioned.
This agreement suggests he has a 20% share in the profits. That's not the case, is it? We've looked at the side agreement.
The official agreement, that's the agreement that gives him the right to 20%. If he claimed the 20%, had the company made profit, he should have been able to collect them.
He had agreed in the side agreement that he wouldn't share in or participate in the profits.
That was his right, but if he decided to take them, he would take the 20% and pay 150,000.
Suggestion that he has a 20% share in the profits is misleading, isn't it?
Why? Because it's different from the shareholding.
The day before, he signed an agreement renouncing, waiving his right to profit.
waived it against a fixed fee. But then if he wanted to claim it, he would get 20% and not 51%. His actual shareholding was 51.
I suggest to you, Mr. Atala, that what is said memorandum in the company contract is wrong. It's false. And it's false because what had been agreed the previous day in the side agreement made it absolutely clear that Mr. El-Halo was not entitled to profit and was not a real shareholder in the company.
But the two documents don't contradict. They can work together. He can renounce his rights to profits and take 50,000, or decide to take his profits, which are 20%, not 51%, and pay 150.
We look at a letter at 1696. Recognize that. Just explain the purpose of the letter.
Signing this to GlobeMed Limited, the company who was funding GMGHS, because it was bearing all the financial investments and the losses and the profits. So he signed on saying that gives the right on the sale to GlobeMed and the revenues of the company.
He acknowledges that he holds the shares in GlobeMed's name and for GlobeMed's account. That's the first paragraph. Second paragraph says we don't have the right to dispose of, transfer, forfeit, or use them in any way. We don't have any acquired or other rights to dispose of these shares to any person or third party. And then if we skip on to the fourth paragraph, we hereby finally, completely, irrevocably waive these shares to GlobeMed Limited. I'm just curious as to why this letter appears to be some date in 2014. Sorry, the 7th of April 2014. I'm really asking if you can recall why this document was produced.
This was signed by all of the shareholders. So this document, whenever we have shareholders that are not participating in the capital or paying in the company investments, they sign it, whether in the UAE or elsewhere.
This is not from a local lawyer. This is from GlobeMed in Beirut.
Yes. This document is signed by a lot of the shareholders in many territories where they do not wish to take the risks and the financial risks.
Where there's a nationality requirement, for example, you would require the national partner, so-called, to sign one of these.
In Lebanon, our shareholders are all Lebanese, and half of them have signed the same document, and they can hold shares with no problem. So no, this is not only a nationality requirement.
Did you draft this document?
Yes.
When you refer in the second paragraph to trust, do you see there?
Yes.
Our possession of these shares is on trust. Have in mind the common law notion of a trust?
No, that was not drafted for Adil. That was a template already being signed since 2008, 2009. So that was the format. The template was there long before Adil Hello. We just removed it as part of because it applies to the same model.
I think I'm really just asking what you meant by on trust when you drafted that. I think.
Because in these situations, the purpose is GlobeMed Limited bearing all the risks and the financial risks. So we wanted to make sure that to protect the company to protect the rights of GlobeMed Limited.
What did you mean by waive a share? I'm just slightly curious as to what that means. Sorry, right at the end, the last but one paragraph. Accordingly, we hereby finally, completely and irrevocably waive these shares to GlobeMed Limited.
The rights, the intention was the rights.
We just look very quickly at bundle L 156022.
I truly can't, but I'll find it too.
Tim, do you have the...
The structure of the company.
Yes, it's those two announcements. Slightly scary.
1498.
1498.
Yeah, we're missing the third page, but you didn't refer to it.
F1498. The Lordship have that.
The one we spoke about.
We saw yesterday, yes. Do you have that on
Yes.
screen? This is obviously a document with the GlobeMed heading. Again, you would have drafted it. Can you just explain why it was drafted?
That was drafted when we first started the negotiations with OIC. We wanted to explain the model and the details of of GlobeMed Gulf Healthcare Solutions. So I explained this in full details and transparency to my colleague at the time, that was Anwar Al-Khatib.
Thank you. So it basically articulates the difference between the nominal position with Mr. Hello owning 51% and, as you put it, the actual ownership where GlobeMed Limited had 91% ownership.
This was to reflect the side agreement and the shareholder agreement, explaining in more details the documents we have signed, and I had sent as well all these documents.
If we can wind back in the chronology, you were not involved in the initial marketing or approaches to OIC, were you?
I remember I was first involved starting August.
And by that stage, the initial approach had been made, I think, by Mr. Latayev?
I guess by Mr. Munir as well.
So
By Mr. Munir Kharma as well.
Mr. Kharma as well. We look at F1447. This is a task list which is recording tasks being done in 2014. And this would have been pre-Beirut, wouldn't it? Beirut was January 25th, the meetings in Beirut.
Yes. The date of this document is? There's no date on the document.
Not entirely clear, but it anticipates certain, if you look at the second item, for example, it anticipates it being, a task being finished in December 14. So I think we can infer that it's probably a document from 2014.
I don't know, I can't say.
We scroll down.
That must have been part of an email. Maybe we can know from the date of the email.
We scroll down. Sorry, can we go? Yes, if we could just go back, sorry, a couple of pages.
What page are we on?
Sorry.
Item number is better.
Yes, let's stop. I think we're at 1448. If we look at the right-hand column, most of the GLOBEMED work is being done at this stage by Mr. Tomey, leading the project on the ground in operations terms.
Yes, but he had a team with him. I don't know if the name was put there, if he'd do it personally or his team, or assign it to one of his members.
So, for example, line 22, same page, HAAD DHA approval.
Line 22.
That, do you have it? Line 22. That appears to have been assigned to Mr. Tomey, that's right, isn't it?
Yes, but not, he wouldn't have done it in person. We had a lawyer handling this with the legal team.
It doesn't refer to the legal department here, does it?
No, it's all Elite Ahmed. None of the other GLOBEMED people names appear here, so it's
Okay,
probably Elite Ahmed and principal being GMJHS.
Could we scroll down a couple of pages?
48.
So stop. What page are we on now? (1451). Could we look there and could we go to the bottom of that page? So the highlighted boxes, if one looks in the right-hand column, where it says legal department, that's you in effect, isn't it? So where you're assisting Mr. Tomey in particular tasks, that is shown in this table, isn't it?
These documents, the drafts come from our side with the lawyers, so there's no involvement of Elite Ahmed on the ground at all. These are contracts. That's why it was legal department and Saloon partners. And the HAD DHA license, he was on the ground, but I've submitted, as part of my evidence, emails in which he was communicating with my colleague Mariana Jabour. She was handling closely the HAD and the DHA renewal with Eli at the time.
So your function, as far as this table is concerned, was primarily the preparation of legal documents.
Mainly, yes.
At this stage, you were presumably liaising with Mr. Khatib, Anwar al-Khatib.
Correct.
He was essentially your counterpart on the other side, wasn't he?
It was Mr. Anwar al-Khatib and it was Ms. Hajar Fadil as well. She was involved mainly in all areas, in the negotiations.
Wasn't a lawyer, though, was she?
No, but she was leading the project to a large extent.
We look at 1786. The due diligence request list. Confirm what this document is doing.
That was the part of the due diligence in the under the MOU to work in the process of the acquisition of the shares. That was before, if I'm not mistaken. Yes, it's 9/10/2014. Before the signature, the OIC conducted a due diligence. They requested a list of documents and files to review. They went very much in depth in the company before signing the acquisition of the MOU.
Didn't they? And this list reflects the requests essentially made by Mr. Khatib.
I don't think it was Mr. Khatib, no. It was someone else, and I got this list, yes.
And we don't see anywhere, there's no reference in this list under corporate documents to the side agreement, is there?
Percentage ownership, organizational documents, bylaws and the company, including all amendments thereto, shareholder register, shareholder agreement. The side agreement was the shareholder agreement. That's how we refer to it. And the document you showed me a bit earlier with the description of the shares, that was part of the submissions I made under this.
You describe the side agreement as a shareholder agreement, but if the person making this list had been aware of a side agreement, they would have asked for a side agreement, wouldn't they?
And it was a shareholder agreement. The word side agreement, we're using it now, but that wasn't, it's not the title of it. It's not,
The side agreement doesn't describe itself as a shareholder agreement, does it? It just has agreement at the top.
Right, but it was intended as the shareholders' agreement between the shareholders.
I suggest to you that whoever in OIC composed this list did not have a side agreement in mind when they asked to see shareholder agreements.
But we submitted it under this list.
My understanding from Mr. Khatib is that the due diligence happened by an inspection of documents on site.
Some were on site and some were sent over, depending on the content and the quality and the size of the documents.
And his evidence is that he could not take documents from your premises. He was allowed to look at them at your premises. I believe he may have visited Beirut for that purpose.
Visited here as well. The documents were, part of them were here. Yes, there are documents that they saw on site, and there are documents that we sent over.
And the documents he saw on site, he was not allowed to take copies, was he?
That was before a contract was signed, or any document. There was only an NDA, so there are confidentiality and particular terms and provisions which we consider are special and confidential to the company, so we don't usually distribute.
And the side agreement was an agreement that you didn't allow him to take from the premises, wasn't it?
If you can see all the legal documents of the company, not just the side agreements. Even the network contracts, because there were third parties involved as well, they could only see on site. We did not send these.
So these corporate documents listed here from 1.1 to 1.8, he couldn't take off site.
1.6 they did, 1.7, 1.8 they did. The ones listed 1.2 to 1.5, based on what it says.
Thank you. Mr. Khatib's evidence is that when he was shown the side agreement on site, he had some concerns about it, worried that it may be a fronting arrangement.
Not at all. That was never raised nor discussed, nor verbally, neither in writing. We did not hand them copies of the side agreement, but I handed by email the description of the shareholding, that the document you showed earlier, that was sent by email. It described in details the distribution of shares.
You say, in terms of his inspection of the shareholder agreements, you accept that you didn't show him a copy of the side agreement personally?
Me in person, you mean? I don't recall, to be honest, if I was available on this particular meeting. I was flying in and out. Years ago, I forgot.
You say in your statement you do not recall Mr. Khatib raising concerns with you. And indeed, you say also you are not aware of Mr. Khatib raising concerns with you or others. Is it implicit in that he may have done?
No. Not at all. These were disclosed and these were included clearly in the MOU, in the documents. We showed them everything. We sent them over. Everything was clear. And in the MOU, which we drafted, we sent to them. They put comments. That was never... They put comments on the side, on all the areas. That was never even highlighted or question was never asked about it.
I'm focusing particularly on his concerns.
No. No concerns were raised.
Why do you say you do not recall him raising concerns? You weren't aware of him raising concerns?
Because he never raised these in front of me. He never, although we were working on the legal documents together.
Implicit in those formulations, isn't it, that he may have raised concerns?
No, I can confirm he never raised concerns.
So your memory has improved since writing your statement. When you were writing your statement, you couldn't recall him raising concerns. Now you can say categorically he didn't raise any concerns.
Categorically, I said he did not raise concerns in front of me. Yes, he did not. Neither by email, neither as a comment to the document. They had added comments on the document and edits and changes and questions. There was no comment on this part.
I would suggest that the formulation in your witness statement is the correct formulation, which is that you don't recall him raising concerns.
He did not raise concerns. To me, I mean, I can confirm, to me, he did not.
So he could have raised concerns to other members of the GLOBEMED legal team?
I wouldn't know. I was working mainly with him. He wasn't, I think, involved with the rest of the team.
You produced a document, Legal Procedures and Actions. Do you remember that? That's at 2116. This is a document you wrote, presumably.
Yes, mainly with the help of one of my colleagues in the department, yes.
Scroll down. If we look at 1 little Roman 4, reference to the signature of the local sponsor, Mr. L.L.C. So he's referred there to as the local sponsor, isn't he?
Yes.
No reference in that document to the side agreement or to him waiving profits, is there?
In this document? A signature of the local sponsor, Mr. Adil Halu, of all needed documents to effect the transfer of the shares he holds in trust for GLOBEMED.
So we infer the existence of a side agreement from the reference to trust, is that right? We infer a reference to a side agreement. My point to you a moment ago was there's no reference to the side agreement in this document, is there?
No. No, I don't see a reference to it specifically, no.
Turn on
Here, I don't know if on other pages.
If you go back to the task list, please, at 1447. Look at line 228.
Two eight.
Go to line 2. So this is the legal department notifying concerned authorities. I think the concerned authorities are include the DHA and the HAAD. Sorry, I didn't hear. Thank you. Did you say yes?
Yes, sorry.
I'm grateful. Sorry. So the assumption is that GMGHS is already licensed with those health authorities.
Licensed or in process, the HAD was on process. We submitted the HAD license. We got the incorporation documents and the approval in early March. We prepared the documents, submitted them by end of March 2015, and we got the license on the 27 May 2015.
Now, the integration of GLOBEMED's client systems, obtaining regulatory approval, persuading providers, I think we've referred to it as transfer or transition, that process could presumably take many months, couldn't it?
And the transfer for new clients?
Yes.
Yes.
So when you're doing a TPA in a country, there is a process, I'm going to call it transition, whereby an insurer essentially transfers all its lives over to GLOBEMED.
They either transfer the lives or there's a system integration that has to be developed between them with the details of the specific terms and conditions. Yes, it takes time everywhere, yes.
And that would normally take a number of months, wouldn't it? Does it ever take longer than that? Does it ever take years, or is it? And you would only start the contractual period or the contractual term after that transition had occurred, wouldn't you?
Sign the contract and then we start the transition, because the transition includes system development or integration. That means there's an investment and there's the technical team that's involved. There's a transfer of confidential information, medical information. We cannot do that unless the contract, there's an investment of the team and resources that are being, of course, we sign the contract with the client. A few months after, depends on the requirements needed, the services begin to.
The contract period from the go live date, isn't it? The transition period doesn't come out of the contract period. The process of transition, which you've just described, which can take a number of months,
Right.
is completed before the contractual term starts. So if you have a 3-year term, deal with transition, and then you have a contract term from go live for 3 years.
You mean in the contract? The contract for me as legal, I consider it from the day it's signed. The rest of the details are operational. I don't know how they usually calculate these. Signed contract when it's signed. Parties.
Your understanding is that the term, however long that term may be, includes the transition period.
Doesn't begin before. We cannot employ resources and put the efforts or take their data. They wouldn't share their data.
So if the transition, for example, took 6 months, the actual period in which you would be servicing the relevant contracts would be 2.5 years, because you'd have half a year.
Services, yes, but the contract would have started on the signature date.
Your evidence is that the contract term started on the signature date.
My evidence? The contract was signed
No,
on
not-
the 13th.
Your understanding would be that the contract term included the period of transition, the initial period of transition.
The transition comes after the signature date.
Am I right that Eli Tomi no longer works for GLOBEMED? Is that right? Based in Dubai, to your knowledge?
I don't know. I know when he left, he was still in Dubai. I don't know where he currently is.
You know if he was asked to give evidence? There was some pressure, wasn't there, on the commercial side to get to an agreement, to get OIC signed up, wasn't there?
We were working towards this, but pressure on the commercial, I can't answer that.
The answer, you weren't aware or no?
I don't know. I wasn't aware.
If we look at the, well, first of all, TPA agreements, they are your bread and butter, aren't they? I think you say you draft and you maintain a library of templates of TPA agreements.
They're all based on our standard contracts. There's changes depending on clients and few terms that change between one another.
We look at 2049.
Shall I suggest in 5 minutes we'll take a short break
My
for
lord, yes.
those 10 minutes maybe.
This is the agreement that was later signed, isn't it? If we look at the footer at the bottom of this page, so this is a draft that was copyrighted in 2014. Was this one of the library that you had drafted?
Have our standard contracts, yes. But these change, if you see it was signed with the word final V01013 because that was the one being exchanged, so.
Does V10 mean that this was probably the 10th draft?
No, 10, I don't know, maybe yes.
If we just go up the page a little. Logo, would that be the particular company?
GLOBEMED logo, yeah.
So
But
GMG Chess would have its own logo and that would be inserted there.
yes.
During the negotiations, did you have carriage of this document? Were you in charge of the document? So there was a master copy, presumably, as it was negotiated.
There was a version we sent over to them. They put their edits. We came back and we reviewed back and forth.
When they're in Beirut, as I understand it, there were meetings. No doubt during the course of those meetings, amendments would have been suggested to the draft.
Yes.
Who would have been the person making the amendments to the draft?
There was an assistant outside. We were in the conference room. We would ask her to change. She would give us printouts for review. We amend again. We give back.
And insofar as instructions were given to the assistant, would it be you that was giving the instructions, or would there be others giving instructions?
We're sitting around the conference table, so it was me, Khatib, Ms. Fadil, all the team that was involved at the time. Mainly Mr. Roger as well. So we were reviewing the last changes, so probably either of us we were discussing with her.
Now, the agreement has a date on its face, doesn't it, if we go down this page?
Yes, that's my handwriting.
And if we look at page 2052, if we see at the bottom there, hold it, effective date means the date on which this agreement is duly executed. Effective date would have been the 13th of January 2015.
Yes.
Then if we turn on to page 2064, this is the definition of term, and it's been left blank, hasn't it?
Yes, that was my error. Those contracts were in my hands, last version. I put the dates on the first page, and there was a date next to the signature. It was my handwriting, I put them on both versions, but at the last minute, and we were wrapping up by the end of the day, it skipped my mind that there's a date inside that I would flip and have to complete that. So when OIC left our offices, I was looking through the documents to make sure all was in order. And I noticed that, so I immediately sent an email, I think 10, 15 minutes after they left the office, noting that this needs to be completed. That was my error.
If what has been intended is that the agreement would commence on the 13th of January, as a matter of drafting, all you would have needed to say is this agreement shall begin as of the effective date.
Right? It's a matter of drafting, but that's a draft that continues edited. Definitely, this probably should be
This draft
fixed moving forward.
This draft envisages a commencement date different to the effective date, different to the date on which the agreement is signed.
No, it was my error. That was my handwriting. The documents were in my hand. Had I remembered at that second, I would have flipped completed like I wrote on the first page. I would have added it and handed both to both parties. It skipped my mind. It's in the middle of the contract. I had a whole lot of issues handling at the last minute.
The fact, as a matter of drafting, you've left a blank is precisely because the date may be different. The commencement date may be different from the date on which the agreement is signed.
No, there's only one date. As a contract, this for me is a legal document that's under my responsibility as a contract. I put the date of signature. Anything after that is operational. These are the people operationally that handle when the transition period ends and when it starts. That has nothing to do with me as legal. For me, I have a legal document binding the company, binding the other party. I'm done. My work is done.
Why doesn't it just say the agreement shall begin as of the date of signature, as of the effective date? Why does it leave it blank?
Because we complete it, and then the first page was added as a design or decor, and I realized that this having 3 dates creates having to memorize or remember that I have to put the dates 3 places.
This is one of your stock agreements.
Yes, but the cover page, not all our contracts have the cover page. That was added later to make a bit of a design for the contract. So it was only...
It's a 21-page agreement. You would have known this agreement inside out.
Yes, I did. And it was my mistake. I should have flipped within. I completed at the beginning, and there's a date next to signature. If we go to the signature page, there's a date there. It's completed because we signed. It was open. We added this. But that was in the middle. It skipped my mind. Too many issues going on these 2 days.
If
Research and
I've
trust.
just got one more question.
Yeah, all right.
Lord, and if there were conditions precedent, then the agreement would have been binding when those conditions were satisfied, wouldn't it?
But we would have put them, yes, and I would have put them in the contract. Have contracts with conditions if that was an agreement, add them within the contract.
Right, shall we break for 10 minutes? Enough? Yeah. Thank you. Okay.
Initial drafts of both the MOU and the TPA were circulated on the 24th of September 2014.
Remember, I sent the first version to Patrick Chaffel. May I check the date? I don't know.
References paragraph 38 of your statement at page 305. Does that help you to refresh your memory? Does that help? They were in effect a suite of documents, weren't they?
Documents, the MOU and the agreement, the TPA.
They were a suite of documents, weren't they? Suite of documents. They were interrelated.
Yes.
They were different aspects of the same joint venture, weren't they?
They're different. One was at the level of the shareholding and the other was as a client.
The MOU was a preliminary shareholder agreement for the joint venture, wasn't it? For the joint venture company.
Yes. The company existed. It wasn't to be incorporated.
You saw the MOU as a binding legal document, didn't you? For example, it was to prevail over the terms of the franchising and licensing agreement, wasn't it?
No, I don't. No. They were different.
Just turn up 2098.
Yes, I stand corrected. You're right.
We look at 2102. Clause 11, this MOU shall enter into effect as at the date of the signature by the parties. Was the MOU drafted by you?
Yes, it's also one of our template documents that we use for several operations.
The way you want the document to commence as of signature, that's how you provide for it, isn't it?
That's a different document. All our TPA agreements have this date. The MOUs is like this. They're different. They're drafted differently. And they're templates of each.
And the template includes a blank in Clause 12 or Article 12, precisely because the commencement date may be later than the date of signature.
No, this is a legal document. I put the dates when the contract is done. It's done. This contract, the one with OIC, is the same for all our clients. This date is always left empty to be completed on the signature date.
You refer elsewhere to the MOU as being prepared by Mr. Karma and myself. What was his role in the drafting of the...
He doesn't draft. He gives me the terms that he would like to include or that he discussed with the partners or with the other party. I take the notes and I draft.
Then it goes back to Mr. Karma for his review?
Sometimes, yes. If I think there's something that I need to clear with him before releasing final to the client.
We look at 1833. So here we have Ms. Fadl sending to you various drafting comments, and we see that in the email at the bottom half of the page. I think her comments are in a different font. Yours are Times Roman and hers are Arial or something like that. Is that right?
Doesn't show here, but yes, maybe for differentiation, I think black and white version.
So Ms. Fadl was also, at this stage in October 2014, commenting on your drafting. And at this point, you were flying backwards and forwards between Beirut and Dubai, usually to meet with Ms. Fadl.
I don't know if I had, that was October. I don't know if I started the flying in and out by then. Weren't too much, maybe 2 and then.
If we could go back to the MOU at 2092. Reference to the side agreement in the second preamble. And to the fact that Mr. L.L.C, owns shares in favour of GLOBEMED and that GLOBEMED owns effectively 95% of the shares.
1.05.
Sorry,
yes.
91. Thank you. No detail in this agreement as to how the shares are effectively owned by GLOBEMED, is there?
First preamble says that GLOBEMED and Kharma Holding own respectively 40.
It doesn't, for example, give detail of the waiver of profits in the side agreement, does it? Or any other term, indeed, of the side agreement?
Refers to the side agreement and says he holds them on behalf of GLOBEMED based on a side agreement signed between GLOBEMED and Mr. Adel Halou. And the waiver of shares, both are referenced here.
Doesn't, for example, disclose the waiver of profits, does it? Could you answer my questions? If I say it doesn't disclose the waiver of profits, could you answer that question and not another question that you think you would like me to have asked?
I answered yes, it discloses the waiver of shares.
I asked you, does it disclose the waiver of profits?
The word profits, no. The word shares, yes. For me, it has the same meaning.
We look at Article 15 document. This is the BUPA clause, as it's been called. Now, Ms. Fuddle's intention at the time was as a #1 priority to get BUPA's approval that week. Do you remember her making comments to that effect?
There's an email, yes, that says that.
And this BUPA clause was added at Beirut, wasn't it?
But definitely it wasn't within my original version.
Well, there's no significant email discussion of the addition of Article 15, so I'm inferring that it was added in Beirut.
I can't confirm. I don't recall at which stage it was added.
It was added to deal with a specific concern that BUPA would not approve, wasn't it?
My understanding that it was added because the parties wanted to sign and complete as fast as possible, but BUPA had not yet had the chance to do the due diligence and give its feedback. So this was added because when we proceeded and they wanted to sign to start the mobilization, start the process, the feedback of BUPA wasn't there.
It was added because those on the Oman side were concerned that they wouldn't get that approval, weren't they?
There was no approval. They wanted to be protected. Concerned, I don't know, but there was no approval at the time. They wanted to make sure they're safe.
Oman wanted to be protected. That's really what is behind this provision, isn't it?
Safe that it cannot commit the whole portfolio because there is a part that was related to BUPA and it needed BUPA's approval.
And if BUPA's approval wasn't obtained within a month, then the parties hereby agree that the terms of the MOU and its fee structure shall be entirely discussed and renegotiated. That would essentially mean starting again, wouldn't it?
No, this was not in the termination clause. This accounted, in my understanding at that time, accounted for the ability to be able to increase the administration fees because maybe the number of lives would have been smaller. That would have affected the financials. That was my understanding why this clause was placed here.
I understand they wanted protection and you didn't want a termination provision. What results is this clause, isn't it?
No, it was put separately, not as a termination condition, to protect themselves, the parties, between the parties to the MOU, in terms of to be able to review the fee structure. Because the number of lives affects the administration fees and the bottom results.
I understand that. And if, as a result of that renegotiation, they could not reach agreement, what would then be the consequence?
I don't know.
I suggest to you that the agreement would effectively be terminated.
That would have to be agreed at the time. There was no contractual term for termination. It would have been to be agreed later on.
I'm curious as to why fee structure is said to be in the MOU. It says its fee structure.
There was an appendix that contained the financials, and the fee structure in the amounts there were based on the fee structure.
My recollection is that the fee structure is in Schedule 7 to the TPA agreement. That's at page 280.
These are the administration fees, yes.
Look at that, 2080.
These are the administration fees, correct?
That is the fee structure for the TPA, isn't it?
We were referring to the one of the MOU. There was an appendix in the MOU that contains financial. Reference was to the appendix of the MOU, not the TPA.
But any renegotiation of the fees in the MOU would surely have required a renegotiation of this as well, wouldn't it?
Not necessarily. The other one affects the bottom line of the company. The MOU affects the profit losses of the company. This affects the service of the lives only.
When you refer to the annex to the MOU, are you referring to Annex 2? Helps to look through it. If you could be assisted in looking through the MOU, that would. She's alleging.
They've got it on TPA.
Showing her the TPA, you want her to look at Annex 2 to the MOU. Let's go there.
Okay, let's go there. $2105, thank you. Is this the fee structure you had in mind?
Appendix 1, I think. Appendix 1, not Appendix 2.
Can we go up to Appendix?
Appendix 1, yes. This is the one.
Well, I'm looking at Annex 2. If I scroll up from that within the MOU, I get the signature page.
Yes, the 2 is the handwriting.
Yes.
Yes, that's my handwriting. This is 1.
Okay, so the appendix or annex immediately after the signature page, structure you had in mind in drafting Article 15. So what you are suggesting is that the parties will be renegotiating. This is a P&L income statement. They'd be renegotiating the income statement?
It was not an old P&L. This was projected. The projections.
A projection for how the venture would perform, isn't it, in terms of revenue streams and costs?
That was.
How would you renegotiate a projection?
Because the number of lives, the financials, the numbers here are based on the numbers of lives that include BUPA. So remove the numbers of lives, the premiums. So that would have been required to be relooked at or renegotiated.
I suggest to you, Mr. Tuller, that when you meant renegotiate the fee structure, you were referring to the fee structure in the TPA one.
MOU and its fee structure of the MOU. This is part of the MOU.
This is an income statement. It's not a fee structure.
The projected income statement that includes the admin fees, guarantees on earth. These are the numbers that, based on the whole portfolio, on the number of lives. If the number of lives or the premiums were to be changed, this would need to be changed.
This isn't a contractual agreement as to what fees will be paid in what circumstances. It's a projection as to number of lives, revenue, and costs. Don't renegotiate a projection.
Are based on salaries and wages of a number of employees. They're raised on administration fees and lives, and administration fees from providers, volume rebates from providers. These are affected by the portfolio that the TPA or this company will be servicing. So that the employees will change, the salaries probably will change, volume rebates will change if there's a change in the number of clients.
One understanding of the MOU is that it contains the initial or the transitional or the setup process and arrangements. Is that a fair summary?
Setup?
Arrangements.
For the incorporation, yes. For the partnership, yes.
But also it contains that provision, Article 15, provides an initial arrangement for PUPA approval to be obtained within a month. Is obtained, then, and the share has to transfer, then you move to the TPA, and at that point, the TPA reflects the ongoing commercial relationship. Can you just, if we can go back to Article 15. Apologies. One anomaly is that the heading for this article is entire MOU. I assume there would have been, in effect, an entire agreement clause there originally.
Drafts I sent in October, but
For the entirety of Article 15, including the heading, comes in by way of the same amendment.
may I have a look at my witness
Of course,
statement?
please.
Apologize, Your Excellency, I'm keeping find the draft that I sent.
I think we'd leave that point. We probably don't need to waste any more time. The BUPA clause was not part of your GLOBEMED template, was it? But presumably, you did have TPA agreements where there was a reinsurer whose approval was required.
Reinsurer? No.
Never had a situation like this where BUPA, for example, was required to approve of a transfer of lives.
It wasn't a reinsurance, it was a fronting arrangement between BUPA and OIC.
You'd never come across that sort of arrangement before?
The approval of the reinsurer before the client signs in? Not that I would be aware of as legal, no.
Not
Or
that you're
as a
aware
part of the contract, no.
And if that situation had arisen, you would have expected to delay the TPA, wouldn't you, until the approval had been obtained?
Signing unless approval was to be obtained would have been obtained before signature.
And if you had proceeded before that approval had been obtained, you would have made the agreement conditional, wouldn't you?
Never had a situation like this.
And in that unique situation, you were required, in effect, to leave the commencement date blank, weren't you?
Never had a situation like this before. Contract, the dates are placed within the contract when we sign.
The meetings in Beirut went relatively well, didn't they? I think you described them as being productive. Described the parties as being in good spirits. Still your evidence? And on the Tuesday, the second day of that meeting, there were some further minor amendments that were agreed. You don't recall whether they included the BUPA clause? And I think it was you that prepared the final execution version of the TPA agreement and the MOU?
It was the assistant outside that was coming in and out, yes.
She would have brought to you the execution version, wouldn't she? That version would have been read by those around the committee table?
Yes, there was me.
All of you would have read it, wouldn't you? Or signing. And you as a lawyer would have been particularly careful in proofreading that document.
Drafting, yes, I would say yes.
And I think the agreement was signed by both Monsieur Farron and Monsieur Chauffel, is that right? They were both very experienced businessmen. They hadn't been involved in the negotiation, had they?
Copied in some of the emails, yes. Were involved. Mr.
But in
Chauffel
the
sent in some comments.
Sorry, you're right.
Mr. Chauffel had sent in comments and on his comments on the MOU and the TPA. Of the emails, it was direct from Mr. Chauffel.
Insofar as there'd been heavy negotiation on the 12th and 13th of January, they wouldn't have been in.
We're all in one room. We have one in the office. There's one big conference room. We were all in that conference room, but they did not. If they did not read the last text, Mr. Farron and Mr. Chauffel, because there was the legal present.
Can I just clarify, insofar as you had long negotiations in GLOBEMED's offices, were Mr. Farron and Mr. Chauffel sitting in those meetings and those negotiations?
Most of them, yes. Most of them.
They would have read the final agreement before signing it, wouldn't they?
Not in details, no.
If we look at page 2064, could you identify the initials at the bottom of that page?
Third one.
You would have looked at this page as you added your initials, wouldn't you?
At the bottom of the pages.
Looking at it, you would have seen a visible gap, wouldn't you? Third of the way up the page.
Saying my error was the document was like this. We would open initial because there were two of these. There was the MOU. There was the corporate documents of both parties being exchanged. That I had not noticed that this was missing. If I had, I would have filled it by hand like I filled on the first page.
I suggest to you, Mr. Tuller, that you would have wanted, you wouldn't not have wanted, sorry, the contractual period to start until the launch.
Contractual period started on the date of signature.
Turn to page 2125.
That was my email at 5:19, but it shows they left our offices around 5. At 5:19, I sent the email. 7:19 because that's when Hajar opened it and Dubai time, so that there's a change.
Bottom, actually. So what happens is at 4:59, you send a final signed draft. Is that right? Looking at the bottom of the page, sorry.
Yes.
Then if we go to page 2113, at 5:21, you then send a list of the legal procedures.
No, I sent the other one first.
Sure, that was 4:59.
And then the 7:19. 7:19 is 5:19. And this is 5:21. We're reading from two different timelines.
Let's look at this. I think you say it's 5:19, and it's marked 7:19, but it's 5:19. Is that right? Let's look at that now. That's at 2114. This is the email where you seek to explain that the you'd have omitted the starting date in Article 12, essentially by oversight. Reference an agreement you allege that it would start as of the 13th of January. Then if we go to the response to that from Ms. Fuddle at page 2124, her response at the bottom of that page, I think you accept that it's after she got off an aeroplane arriving back in Dubai. Considering we added the BUPA clause with a month period to get written approval from BUPA, the agreement can only be effective from the date the approval is obtained. He's implicitly denying that, in fact, there had been an agreement at Beirut.
Correct, she was denying that was not the agreement. That was a contradiction between what she and her email. Then
She makes, sorry, go on.
by Mr. Saliba.
She makes clear that the agreement can only be effective from the date of BUPA approval, doesn't she? That's her understanding of the BUPA clause, isn't it? And you referred to Mr. Saliba's email. That we have at 2124, in fact, just up the page, don't we? So Mr. Saliba responds, the agreement takes effect as of signature, so he reasserts the position that you've already asserted and which she's already denied. Says the BUPA clause will not affect our mobilisation plans. And he asserts that, as you do, that there was some discussion and agreement on this point, notwithstanding the BUPA clause. And responds to that effect. Now, the response of Ms. Fuddle at the top of the page, essentially that there is no need to have a dispute about this, because both parties are keen to mobilise and move forward. I would suggest to you that if there had been a specific discussion or agreement that the TPA would become effective, commence on signature, it is inconceivable that a lawyer of your experience would forget to amend the TPA.
Amend?
Well, you're alleging in these emails, as is Mr. Saliba, there was an agreement that it would commence as of signature. Is that a fair summary?
Right.
And you did not, in fact, amend Clause 12A to that effect.
I was supposed to add the date. I missed the date. I commit an error. I commit a mistake under the pressure of that day.
My point is that if there had been a specific agreement about it, you would not have forgotten to amend Clause 12.
Right. None of us would have signed if that was supposed to be there and they didn't see it there.
The truth is that you never expressly agreed in Beirut that the TPA would be immediate.
It was immediately binding, yes, we agreed.
And if we turn to page 2177, what you then do is essentially to keep repeating your understanding. So this email, we see there, dear Anwar and Hajar, please find attached scanned copies of the following contracts, TPA agreement, the end, effective as of 13/1/2015. So you again hope that they will accept your assertion as to the effective
I
date.
reinforced this because there was an error at the beginning when we signed, because there was an error on a back and forth emails. I clarify.
And you send a signed copy of the TPA, don't you? And the copy you have in fact sent has been amended by you by hand.
Yes, I had my original, they had their originals.
Send a further copy for their file that has been amended by you, don't you?
Completed by the date. Yes, I sent it scanned.
Or amendments, you have made that change.
I notified them by email when I did it at 5:19 on that same night.
Don't draw their attention in this email to the fact that you've made that amendment, do you?
That was in 21 January. I notified them on the 13th of January at 5:19 that I amended and completed it by hand, and I asked them to complete their copy by hand as well, because they had their originals.
They've explained to you that they don't agree that there was such an agreement.
But then when we replied, as Mr. Roger Saliba replied and explained, there was no reservations from Hajar anymore.
But he's just
Our understanding was that she agreed.
Well, no, she's made clear that she didn't agree.
Try again to Mr. Roger Saliba, so we thought that she had accepted.
So having denied what you said, when Mr. Saliba repeated it, took her silence to be a change of position. She was now accepting what Mr. Saliba was saying about there having been a specific agreement.
That was our understanding, yes.
I'd suggest you had no such understanding, and that what you were seeking to do by this email was put on their file a copy of the agreement which you had amended by hand without making that clear in the face of this email.
That was to correct the error that I had made.
Sorry, if you just bear with me. If the TPA had been immediately effective, that would have required you to be providing the services immediately, wouldn't it?
Transition period, we cannot provide the second day, we don't have their data, and there was supposed to be a shift by their information. That required time.
But the contract doesn't provide for part of the term to be taken up in a transition period.
Yes, because that's operational. None of the contracts do with all our clients across all the operations. These are left operational depending on how much time each client would.
Critical date is when the transition is completed, isn't it? When the services can be provided for the 3-year, for the term of the TPA. That's the critical date.
When the services begin.
Yes.
Contract begins before, otherwise the transition period cannot begin. We cannot mobilize and put resources and employees and the technical and receive confidential medical information.
You were mobilizing in the knowledge of the BUPA clause, that essentially they could renegotiate the fee structure. You were mobilizing, as Mr. Saliba says, in the knowledge that they did not accept that there had been an agreement orally in Beirut that the term would start as of signature.
Right, the parties were mobilizing because that was their intention and that was the reason why they wanted to sign and proceed.
GLOBEMED took the risk, didn't it? It knew that under the BUPA clause, if BUPA's approval was not obtained, then the fees could be entirely negotiated and potentially the entire joint venture could go off. It knew that, didn't it?
There was no risk. In reality, what we believed within GLOBEMED is that BUPA would have come in anyway because Synergize was supposed to purchase 51% of GMGHS, which would have rendered GMGHS a subsidiary of OIC, which means it's still part of OIC group. We were really, the option of BUPA not coming in was not a risk for us.
Well, I entirely accept you didn't see it as a significant risk because you thought in reality, as indeed did Ms. Fadl, that BUPA would come on board. But the risk was still there, wasn't it?
There was, of course, there was still a risk. Written approval was not received.
And the risk under the BUPA clause was that if BUPA didn't approve and the agreement went off, you would have wasted a month of resource in mobilizing.
Shareholding and the partnership, this would not have been, this would have proceeded. The financials would have been impacted, whether with losses, profits, this would have been impacted, not the whole partnership. We were working towards the partnership.
I don't think we need to go back to the BUPA clause. I think we've discussed that and its implications.
And
Risk that was involved under the BUPA clause
Right,
of
and
a
if I may-
fee ending in the agreement effectively being terminated. Insofar as there's a renegotiation of the fee structure.
So, Mr. Reid, is this a question or?
Well, I think I've asked these questions, which is why I'm going to not go back there. Thank you. Now, in terms of licensing, you had no particular training or expertise in UAE regulatory law, did you? So insofar as you express opinions about regulatory matters, they would essentially be the opinions of others, wouldn't they?
either from the lawyer or from the documents that we would have received from the regulatory authorities or.
We look at page 398. Look at paragraph 26. Wish to clarify by way of general background, then paragraph A, halfway down the paragraph, it's my understanding that several insurance companies and TPA providers were required to take further steps to ensure compliance with the newly implemented DHA requirements. That's, again, an understanding from someone else, isn't it? It's hearsay, essentially.
From the emails and the circulars that were issued by the DHA and emails received mainly from.
And when you say at little c, to the best of my knowledge, that's recognizing the same reality, isn't it? Which, just out of curiosity, which other TPAs, to your knowledge, failed to satisfy the DHA requirement?
And that was by email. It wasn't. Several TPAs at the time did not meet the patient checks, security checks. The reason was a technical issue between the codes of the TPAs, of some of the TPAs and the DHA. There were reasons. That was raised by an email from DHA in mid-February, and they gave the TPAs until the 31st of March to remedy their situation and to submit the new requirements, and GLOBEMED was one of these. DHA was supposed to give feedback by the end of April, but it went silent until 16 June. That was the first issuance of licenses and approvals official. We were unconditional, and OIC was unconditional.
At the time, it was Mr. Tomey dealing with all this, wasn't it? All the regulatory and licensing issues. That understanding you've just laid out, based on your recollection from the time, or is it based on more recent studies?
Of the documents and my discussion with my colleague Mariana, who was my team member.
So to that extent, it's essentially her evidence. reviewed her emails?
Some of which I'm copied on, but I do not go through the details. If it's licensing, I know she's handling. I don't review. But now to go through these, yes, I went through the emails.
There were delays in respect to the HAAD, Abu Dhabi license. Part of that was a delay in setting up the GMGHS branch office in Abu Dhabi. Is that fair?
And the setup of the Abu Dhabi branch in November 2014, when during the negotiation period with OIC, it was mainly because OIC was required that we do that to service their portfolio in Abu Dhabi. We submitted in November, got initial approval in December. We got the final incorporation early March of 2015 for the Abu Dhabi branch. We prepared the documents for the HAD license and we submitted them by end of March, 31 March. We got the license on the 27th.
So by reason of the delay in getting the branch office until early March, the application for the Abu Dhabi license was delayed until the end of March, the 31st of March. That's right.
Right, yes.
In preparing your statement, you were shown various documents, weren't you? So if we look at page 401 in D 401. Sorry, I thought that's a bad reference. I'll come back to that. And the Abu Dhabi license was not in fact obtained pursuant to that application until the 27th of May. By the time of the notification letter on the 21st of May, there was no Abu Dhabi license. And indeed, by the time of the 24th of May, which had been the anticipated go live, there was no Abu Dhabi license.
And which was received on the 27th of May, week after the termination.
Turning now to the DHA, the Dubai license, requirement to make an application by the 22nd of January 2015.
Yes, we said by the 25th. We did it by the 21st.
And the application was for unconditional status from February 2015.
February 2015. We were supposed to comply with the requirements and get the approval, yes.
And the license you were applying for would have applied from February 2015.
February 2015 was the deadline that all the previous licenses would remain effective until 15 February 2015. That was one of the emails of the DHA.
Thereafter, when those licenses were no longer effective, you would require a new license.
The DHA sent an email requesting the TPAs that did not match on the drug safety checks, because that was the same point for several TPAs due to an error, the technical issue between the list. So it gave the companies until the end of March to submit the new requirements for the drug safety checks, because these did not comply with its requirements.
Can I just understand, you'd been informed that the existing licenses would be effective until mid-February. I think you said the 15th of February 2015.
Right, that was sent in the email of the DHA of the 1st of January when it released the new requirements, and it set a date for the 25th of January to submit these.
And GMGHS failed, as I understand, because it had not complied with a drug safety check requirement, is that?
Right, we did not comply. Us and several other TPAs, of which GLOBEMED submitted by OIC as well.
And that had the consequence that OIC's HIP, its health insurance permit, and GMGHS's HIP as TPA were then conditional.
License issued by the DHA. There were emails at the time. The first licenses that were issued on the 16th of June. Before, it was a back and forth emails with DHA.
The risk at this point was that you would only get a conditional authorization.
Risk had we not complied, yes, but we complied before the deadline.
Risk of continuing to fail to comply would have been a conditional authorization.
Conditional, but according to the definition in the circular that was issued by DHA, conditional continue to operate as a company, but you would need to comply with the requirements.
And if you didn't comply, then there was a risk of your permit or your authorization being suspended.
Possibly.
Just look quickly at 2735. This is an explanation to Mr. Khalifa, referring to issue of compliance, and halfway down the third paragraph of that email, in bold and underlined, if full compliance is not achieved by this final date, the conditional compliance status will be changed to permit suspended. So that's what you were up against, isn't it? That was the risk.
There was this risk, yes. Had we not complied.
And to the extent that GLOBEMED as a TPA was on the HIP of OIC, that was a risk too for OIC, wasn't it?
Yes, two of OIC's TPAs were not compliant in the first submission, GLOBEMED and GlobalNet.
And unconditional status was not given to GLOBEMED as TPA until the 16th of June, was it?
No one was given until the 16th of June. First issuance of the whole list submitted by DHA. The list contained a conditional, unconditional, and I think there was we were unconditional, OIC and GLOBEMED.
You were considered you were conditional until the 16th of June, and as of
DHA did not issue a list of conditional and unconditional. We were never under the box of conditional. This was never issued.
So between mid-February and mid-June, 4 months, your regulatory status was essentially, your regulatory status was essentially application pending. Is that?
No, because the DHA sent an email on the 18th of February, and it gave the TPAs until the 31st of March to submit the new requirements, the second submission, and it said it will reply back by the end of April, but it only came back by 16th of June, not before. I'm sorry, the AC is getting...
So during that period, we understand that the application was being made, but you didn't in fact, or GLOBEMED didn't in fact have any regulatory approval or authorization in place at all, did it?
We had the DHA permit on February 2014. So the company had the DHA permit, but there was a change in requirements in January. So it's the compliance with the new requirements that was launched in January 2015.
2014 permit expired mid-February 2015, didn't it?
Right.
And I'd suggest to you that there was a significant element of regulatory risk to OIC.
We had the DHA had given all the TPAs a period until 31 March. So there wasn't any suspension, any official notifications, it was only email exchanges with the DHA.
I would suggest to you that it was entirely reasonable that the contract period should not commence until an unconditional license had been obtained.
At the date we signed the contract on 13 January, none of this was... when we signed, we had our permit was still valid, and we were working towards the new requirements.
Prior to the launch, GlobeMed was taking a further risk, wasn't it? It was taking the risk that the regulators would not grant licenses. Well, because if the regulators didn't grant licenses, then the TPA couldn't proceed, could it?
Licenses is a formal process, continuous. We licenses continuously, we comply. It's not something that there was no breach identified. It was a continuous renewal and compliance with new requirements for licenses. Operational matter.
More than a formal process, isn't it?
Sometimes operational when new requirements are issued.
If you don't have the relevant authorization in place, you can't provide any services as a TPA, can you?
DHA permit was required for to service the DHA program, yes. Wouldn't have been able to service the DHA program. But we would have been able to operate as a TPA based on the insurance authority license and based on the trade license.
So you needed a relevant license in each relevant emirate, didn't you?
Needed to be able to operate and serve the DHA program. We needed the DHA license, but we had the trade license of the company and we had the insurance authority license that were valid as a TPA.
Well, you have a business license to operate as a business, and you have an insurance license to work in insurance, but in terms of providing TPA services in health insurance, that requires a specific authorization in each relevant
DHA,
emirate.
yes.
You had no idea, did you, when the launch would in fact be possible?
Services launch?
The time that you're dealing with the regulatory authorities.
Parallel. Preparations were going, operational preparations and license compliance process were in parallel.
The launch isn't specified anywhere in the LPA agreement, isn't it? The launch date.
Service launch date? There were emails. I checked back, there was a date in April and then it shifted to 1st of May and then mid-May, so it was based on the readiness of the operational on the ground.
Prior to the launch, the only real comfort you had was in the efforts being made by the other parties, wasn't it?
Parties were working towards.
Notwithstanding those efforts, the risk remained. Wouldn't get the licenses. The risk remained that BUPA would not give its approval. Your role in the transition period was limited essentially to legal work, wasn't it? Largely absent from the mountain of emails we have on the technical details of transition. Your focus would have been on the share transfer during this period, wouldn't it? Could we look at page 3460? So this is, I can't see the date. 24th of April, told by Mr. Killen. 23rd, thank you. So Mr. Karma has been calling you, essentially chasing the transfer of the shares, pursuant. Go to 3459. At the top, an email from Mr. Kishore, who was assisting Al-Khatib. So the same day, he is attaching a revised consolidated share transfer and Articles of Association amendment agreement for your review. So you're working on that issue. Mr. Karma is chasing you. Mr. Kishore is also working hard on the share transfer. Both sides are engaged on the share transfer. And at 3458, so going back a page, just identify, is it Maître Mariana Yacoub?
Yes.
She, I think you've referred to her as your assistant.
So she's a lawyer within the department.
When you use Maître, you're referring to someone who is a member of the Lebanese bar. And she copied to you is sending an updated version of the bilingual consolidated share transfer and Articles Association amendment. You're dealing with the same documents that Mr. Kishore was referring to a moment ago. It's fair to say that both the Khatib and Mr. Kishore in April 2015 are pressing hard to get the share transfer. We look at 2238. This is an announcement, isn't it? And it's on GLOBEMED headed paper. Would you have worked on this? You have drafted it.
Trying to work between us and.
Would you have been doing?
The base drafting? No, I don't think that was me. There was also the marketing department that helps drafting these public announcements. The amendments in red, would they be the OIC amendments? OIC proposed amendments? Ask me a question?
Yes. Insofar as you can see draft amendments in red,
Yes.
they would have been OIC proposed amendments.
I can't recall. Possibly. I can't recall if it's OIC or us, but.
For example, the third line from the bottom, deletion of partnership and replacement of that with cooperation. OIC change, isn't it?
Document, so I can see that change.
And as I understand it, this announcement was delayed by OIC because they didn't want to issue this announcement until BUPA had provided its approval.
I don't recall this, no. Well, this was specifically delayed for a reason.
We look at 2264. I should start by saying you were not copied or sent this email, but it's an internal email which Anwar says, I would request you to seek more time until we finalise with BUPA. Was that concern shared with you at the time in your discussions with Anwar, Mr. We turn to page 2544. This is an email from Mr. Tomey on the GLOBEMED side to Dr. Partho on the OMAN side. If we look down the third paragraph, this is Mr. Tomey saying, Moreover, to point out, I understand from Hajar that OIC do not wish to make an announcement in the near future with cooperation. In case, I would point out that the timelines may be delayed as there will be more resistance from providers. So Mr. Tomey is recognising another cause of OIC concern at the time, i.e. The providers and the reaction of the providers. Is that something you were aware of at the time?
No.
You in any way involved with negotiations with the providers?
No, I might have been asked to make any changes to
That was
the
being dealt with.
providers.
Sorry. That was being dealt with on the commercial side.
Remind you, Mr. Reid, we have 15 minutes left.
Yes, I'm grateful for that. You were not aware of Bupa's dealings with GMG? Or with GLOBEMED?
At that time,
We just quickly look at 2324.
I mean, I was involved in Bupa's negotiations with GLOBEMED later, a few months after the termination by OIC, because Bupa signed with GLOBEMED to service it in Lebanon and in Kuwait, and we still do to date.
So there were various rounds of due diligence where Bupa teams flew in by ended at GLOBEMED's offices, and we see here in the middle of the page Ms. Fuddle dealing with Bupa, referring to a due diligence visit to GLOBEMED's offices on the 4th and 5th of February. You were not involved in that at all, were you?
I remember there was heavy due diligence from Bupa at the time.
When you say heavy due diligence, what do you mean by that?
They were working on it closely.
And you see here Ms. Fuddle is keen to wrap up that process of heavy due diligence over the next 2 weeks. Good. So you were aware that Oman was doing everything it could.
There was positive feedback from Bupa.
Sort of a line across examination that may take more than 10 minutes. Want me to get halfway or?
Well, we have to break at 12 anyway. So.
Sorry, I don't understand. Is the proposal you'd like
Well,
to break now?
I'm wondering if we break now and resume. That should allow me to finish with Mr. Tull and Mr. Montague-Smith to have the opportunity to read.
My understanding, Your Excellency, is that we have a hard stop at 4 p.m. So we have a longer lunch break now from 12 till 2, and then we have 2 till 4, and we have to stop at 4 p.m. That's my understanding.
And have 30 minutes more.
I see. I'm very grateful. In which case, if my little friend's able to finish by 4 p.m., then that's important. It's important, I think. Thank you.
In that case, can we pause now and resume promptly at 2, if that's possible?
Fine with me. Okay, thank you for that. We'll break now and we'll come back at 2 p.m. Thank you. I just want to apologize for the witness for keep you too long. I think I realized I should finish it by 12:30 instead of staying until 4:30, but sorry for that. All right. Okay.
Could we look at 3030? Now, this is Dr. Panda writing to Ellie Tomey, but copied to you. And OIC is expressing concern at requiring all providers to sign the circular. Do you recall that? And then if you go to the previous page, 3029, Mr. Tommy says, having spoken to the legal department, that's you, isn't it, the legal department?
Yeah.
You would prefer confirmed unless notice of objection. So your preference was that silence should be taken as confirmation, wasn't it? That's your preference.
Right.
There was a real concern, wasn't there, that providers may decline to agree to the transfer?
My concern was that they go silent, because we're saying confirmed unless notice of objection. So if they reject, we're asking them to submit a rejection. And if they don't reply, we would consider this as confirmed. Knowing the number of providers and the way providers lead their work, sometimes they would get the letter and just put it in the drawer and not come back to us.
You were concerned that they wouldn't actively confirm their agreement. I'd suggest that the concern was slightly wider than that you also had a concern that certain providers may indeed not be keen on the transfer.
I wouldn't have, I'm a legal person. I don't know if there were issues with the providers that would lead to rejection or something, but to have it clear that all is, so I know we have a timeline or a deadline of 15 days. Following that, we're okay to proceed, and we just manage the objections.
Dr. Panda, if we go up the chain, agrees, didn't he, that it's better not to seek a confirmatory signature. That was effectively the approach that was taken, wasn't it? Now, in fact, there were real difficulties with certain providers, weren't there? Mediclinic, in particular, was leaving the GLOBEMED network, wasn't it?
I don't have such a recollection. I don't know by name and the reason, but broadly that some of them had issues mainly on financial reconciliation with OIC. They needed those closed before filed the old accounts. This, I think,
they were using a transfer to ensure that they were paid up by GLOBEMED for existing amounts due and owing to them.
OIC amounts mainly. Their work was more with OIC, and they were asked to shift from OIC to GLOBEMED. They were asking for clearance and reconciliation of accounts and closure of outstanding dues before effecting the transfer.
But as I understand it, Mediclinic was concerned about payments by GLOBEMED, wasn't it?
I don't remember. Possible if you have an email. I don't know.
We look at 3038 F2. If we look at the lower email, I got a call today from Mediclinic, this is Mr. Dr. Panda, informing GLOBEMED to be out of network from 3rd March 15 because of payment issues, post a notice of 3 months. I believe you informed us issues with Mediclinic being sorted out, but regret that's not the case. So he's informing Mr. Tomey that actually Mediclinic have financial issues with GLOBEMED and that they have not been resolved as Mr. Tomey thought they should have been or may have been.
This is possible. There's the network is above 1,000 providers, so.
But this was copied to you, wasn't it? This email from
Yes.
Dr. Panda. You would have been aware of the.
I don't remember because it's not my area, so I must have read it diagonally at the time.
Then that prompts Mr. Taldina, also of OIC, to be concerned that GLOBEMED may have cash problems. That shared with you, that concern shared with you at the time?
This email, you mean?
You're right, you're not copied to that email, but were you aware of concerns on the part of OIC that GM might have had cash problems? If we look at 3042, see there Mr. Khalifa expressing concerns as to whether there were similar issue with any other providers. Now that is copied to you. Do you remember receiving that? How did you respond to that email?
The provider issue, I don't go into the trust the people on the ground are handling.
And BUPA were also concerned about providers, weren't they? If one looks at 3270, if we go to the second paragraph, as well as we had discussed that Mediclinic Middle East has terminated the direct billing agreement with GLOBEMED, and recently I got to know also that Mediclinic has objections regarding GLOBEMED managing OIC network and will treat OIC members presenting GM cards only on a cash basis. Going down to the next paragraph, there were some must-have points have been discussed and agreed during the due diligence activity with OIC, and one fundamental point is no worse terms on coverage, servicing and pricing than under existing OIC contracts. I'm sure you're sharing with me that both our members' experience in this market will be very much affected by the level of network coverage they're receiving. Hence, providers' positions such as Mediclinic or American Hospital from the network transition to GM is significant impact over the whole process. So this is a concern that certain providers refusing to transfer will create problems with BUPA, isn't it?
Mediclinic was important to BUPA.
And the sorry?
If I recall correctly, a later date email beyond April, things were resolved.
Well, could we just take this in stages? Could we look at 3281? This is a table, and I think reference was made in that email to the table. If we look at the column third from the right, we see refused, 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 and we see a number of providers in the left-hand column. Scroll down, and we can see at the bottom of page 3282, a number of those are Mediclinic facilities, aren't they? Keep going down. Got there, thank you. It's understandable in those circumstances that BUPA, which is a high-end brand, would be concerned about the transfer of their lives, isn't it?
I'm not sure this is all related to GLOBEMED, the refusal. That was, I think, GLOBEMED and OIC reasons combined, not just GLOBEMED.
Okay, so these are refusals to the transfer, some by reference to OIC, some by reference to GLOBEMED. But as a problem in terms of managing the transfer, this is a pretty significant problem, isn't it?
Yes, it wasn't resolved, yes.
We could look at 3129. This is Dr. Panda to Mr. Tomi, copied to you. Reference to a circular in the first sentence. As shared, this is being followed with a call. We've been receiving many calls to explain the details. I've been personally speaking to people and providers simultaneously. I would urge, if you can take this with Dr. Imran and the rest of the team, to ensure apprehensions with providers are sorted out proactively. So this is the end of March, and Dr. Panda is urging Mr. Tomi to speak to providers and deal with their apprehensions.
Of course, the providers would have wanted to know what's the change and how would it affect them. Doesn't mean that there are problems or issues, just the understanding of the change.
And the particular concern seemed to be with GLOBEMED. That would be the logic of requiring Mr. Tomi to speak to the providers to deal with their concerns.
Yes, GLOBEMED would have served them after that, yes. That was on the same day of release of the circular. So the circular has been released today.
Yeah. At the same time, OIC is sending internal email to key stakeholders, there are concerns as to employee reactions, aren't there, within OIC? Shared with you?
I don't recall in detail.
Presumably, a number of employees have been transferred from OIC to GLOBEMED as part
That was
of
the
process.
plan, correct.
If we look at 3346, there seems to be a concern. So this is Dr. Panda to L.L.C. Look at the fourth paragraph. Contradictory to the above, the information we got is that movement of 5 GLOBEMED resources to other work within GLOBEMED. A resource like Georgette moving out to GLOBEMED by the end of April in between leave. This leaves us with the same 8 resources of OIC managing all the responsibilities instead of 13 assumes the capacity. This clearly looks like a case where there's a need of resource alignment, prioritising key activities with a plan, and engaging resources with defined targets rather than pointing out a single resource to be the cause of failure or delay. So there's a concern expressed there that GLOBEMED are not resourcing us sufficiently, isn't it?
What are the background or the reasons? But it seems from the first paragraph that it was Elite's concern on Dr. Imran. In post-discussion now, I'm not sure the very reasons of your concerns about a resource like Imran.
Where your point is?
I'm not sure the concerns seem to be coming from Elite Army.
No, the concerns are coming from Dr. Panda and being expressed to L.L.C. And so essentially 5 GLOBEMED resources have been transferred to other work within GM, whereas so that the transition is now being managed essentially by OIC staff without the resource of the GLOBEMED staff, and that's been identified. And one sees at the end in the PS reference to Mediclinic and American. So Dr. Panda will try and make sure they get on board. And the rest, I believe GLOBEMED will be able to take care unless you specifically ask me to get involved. So again, it's GLOBEMED who need to talk to the other.
I think, Ms. Reid, we need to avoid those questions where she's not involved in those emails. Just for sake of time, we need to finish by 2:30, including the cross-examination, to start with the other witness.
I'll do my best, but I can't. As a guillotine, I don't think.
Well,
I will move quickly.
the initial timeline was 4 p.m., then we extended to 4:30, but 10 minutes for the cross-examination.
Yes, I have no doubt that we will allow Mr. Whether I will finish by 2:30, I can't at this stage say, but we will
Have the second witness as well for today. Yeah.
Your initial review in respect of BUPA's due diligence was that they were asking to see too much documentation, wasn't it?
Remember, they asked for a document that was corporate related. That's what I thought. That how does this relate to the due diligence operational they were doing?
So for example, they asked to see the transfer agreement between the Free Zone Company and GHS, didn't they? You didn't think that was necessary. You thought they would.
No, because OIC saw it, given that they were coming in. They were coming in as shareholders, but I didn't see why BUPA would want that, being a client that will be serviced.
You thought their due diligence was too detailed, didn't you?
On the legal issues, they didn't ask for much. It was 2 documents. One, I didn't see the reason why. The second, I gave in.
Could we look at 2542? This was a document that was sent, an email that was sent to you. So there have been 3 weeks of BUPA due diligence, and yet BUPA has failed to reach a decision. And what Ms. Fadl is saying to you she's seeking to express optimism, but she's saying at this point we see no need to reopen any discussion of the MOU. I would suggest to you that by saying at this point, she is in effect reserving OIC's position.
Waiting for the written feedback, although she said it was the overall feedback has been positive, but I guess she wanted written confirmation from Bupa.
Yes, but because she expects it to be imminent, she says at this point we don't need to open a discussion about the fee structure under the MOU. That's what she's really saying, isn't it?
Yes, she's saying they have positive feedback, and she wanted to the mobilization. The reason was not to delay mobilization.
She's reserving the right of OIC to exercise their Section 15. We look at 2877. This is an email from you to Dr. Ms. Fadl in respect of the press release that was being continued or considered in February 2015. And there was an issue about whether the shareholding structure should be disclosed. You say the other issue is the shareholding structure. We agree that we want this company to be profit-making, and hence we need to eliminate from the market any fears. As such, stating that OIC will enter as shareholder in GlobeMed Gulf is first incorrect, because Synergize will be the new shareholder, and second, not in the best interests of GlobeMed Gulf's business, because it will stop other insurance companies from signing in as clients, afraid from OIC's access to its data. What she's saying is that if other insurers realize that GMGHS is majority owned by OIC, in effect, that will be a deterrent from them to enter TPA agreements with GMGHS.
It could be a possible risk.
You were told at one stage by Mr. Tomey that he was confident that Bupa would agree. Is there any particular document that you were shown to suggest that Bupa were even close to approving the transfer?
One that you just presented from Hajar, this I think is the...
I see. You were relying on...
There must be others. No, there must be others, but...
But the first one that came to mind was Ms. Fadl's email expressing optimism.
Yes, just read this, yes.
In your initial evidence, there was a suggestion that Bupa had agreed to GlobeMed servicing its lives, Bupa's lives, in Saudi Arabia, Lebanon, and Kuwait. That wasn't quite right, was it?
Right, that was an error in my witness statement because the contract is with GlobeMed Saudi, but the servicing is for GlobeMed. And the second one with GlobeMed Saudi to service GlobeMed Kuwait.
So essentially, that's the servicing of Bupa's Saudi clients when they are in Lebanon and when they're in Kuwait.
Have portfolios resident in Lebanon. So their portfolio that is resident in Lebanon is serviced by GlobeMed Lebanon, and their portfolio that is resident in Kuwait is serviced by GlobeMed Kuwait.
These are people whose insurer is Bupa Saudi.
Right, a sister company of Bupa UAE, owned at majority by the same group.
And we have those agreements, don't we, at F3 3970? Scroll down that. That's the agreement you have in mind. Substantially blanked out, isn't it? Was that?
Correct, because that's a non-related party.
I would suggest to you there is not a shred of evidence that Bupa Arabia relied on Bupa's due diligence in the UAE back in 2015 when it was entering these agreements.
I believe it did because Bupa wouldn't give its portfolio for servicing unless it goes through a due diligence. This is part of the Bupa group. They're all owned by the same shareholder at majority ownership. And when they entered in the contract with GlobeMed Saudi to service Lebanon in 2016 and then Kuwait in 2018, there was no due diligence at the time. Just very high-level reviews. That's it.
There are two problems. Firstly, the due diligence in 2015 seemed to make almost no progress. And secondly, the due diligence in UAE in 2015 was largely concerned with the transition arrangements, specifically in the UAE.
On the network, but there was a lot of processes, a lot of systems, which is the system used in the UAE and the processes are the same across GlobeMed operations in the 12 territories. So
but there's no...
all of them under the same franchising and licensing, similar franchising and licensing agreements.
You are inferring reliance on the historic due diligence in the UAE in 2015. There is no document that suggests that is
Correct.
the case. You say fairly, my understanding is that Bupa's decision was premised, as you say, on the outcome of the Bupa due diligence exercise in the UAE. Yes, there is no basis for the understanding you set out.
It was basically based on the feedback of the general manager of GlobeMed Saudi, who was mainly involved in the negotiations with Bupa at that time. And given that no due diligence was undertaken for Kuwait and for Lebanon.
No documentary evidence of that feedback, is there? Move to the 21st of May notification. You were concerned that it may be read negatively as a failure to obtain Bupa's approval. Parties were pursuing high-level discussions at that point. You were not involved at that point, were you?
Page number, please.
Okay, D312, paragraph 75. So you say, in addition to the above, it was also my understanding. Now, the use of my understanding suggests you weren't directly involved in those discussions.
I was in a part, yes, I was, but in a very small part.
And Mr. Khatib proposed a draft circular to providers. And if we could look at that, that's at 3803. And the critical paragraph, the second paragraph, says, after consideration, Oman Insurance Company has decided not to pursue claims administration through a third-party administrator as communicated earlier. That's an accurate and fair account of what actually happened, isn't it?
It is, but the problem why I was objecting on the release of the letter at the time was that we announced to the providers and to the market in around March that we'll be working together, and then in June, you go back to the market and saying, we're not working with GlobeMed anymore. So that would have a major reputational harm for GlobeMed because the market would have thought, well, GlobeMed started servicing, they messed up, and then OIC left, which in reality, none of this happened. We were still working, no issues was there. And then out of the blue, OIC decided to terminate. So that was, for me, considered harmful to the market. And alongside the fact that we were still pursuing possible.
Could we just look at F3874? It's August 2015, so again, we're post-notification.
I don't want to sound like an exam controller, but 5 minutes left for you.
No, I'm going to hit the 5 minutes one, my lord. I may be two minutes after your guillotine, but I'm going to achieve it.
Appreciate it.
So just to set this in context, this is a Go back to the top of this document, sorry. So this is an email from you, isn't it, to Michel Pharaon and various others. And if we go to the top of the next page, had a meeting, and your report of that meeting, I think it's your report to the GLOBEMED board, is that OIC understood completely our position and had no response or justification to defend what they did. They fully agreed with the blame and the fact they'd harmed us. And then the next but one bullet, in fact, Hajar and Anwar expressed to us that they disagree with their management decision to terminate, but they had no ability to object. I suggest to you, Ms. Atala, that that account is complete fiction.
I reported this, I think, 1 or 2 days after my return from Dubai, and I was being transparent with our board. I have no lying to them if I knew there was something. I reported truly what I heard, the discussion, how it went, and what I believe, my impression of it.
Your impression of that discussion?
That was said by them in the meeting room. I understand that I don't like what I wrote, but that wasn't intended to them. I was reporting to my board transparently.
Could we turn now to page 2098? Could we look at clause 5E1? Sorry, B1, I'm sorry. And we see their reference at the bottom of the page to the standard cooperation agreement with GMGHS. That's the TPA agreement, isn't it? And that's Appendix 1 to the MOU, isn't it? So the TPA agreement is in fact appended to the MOU. It's part of the MOU.
Standard contract that the companies that are subsidiaries or part of the group of the investment entity, yes, or that we're supposed to enter into.
And reference in the MOU at over page at 5B, little Roman 3, to the projections at Appendix 2. That's Appendix 2. That's the projections that we looked at.
Yes.
Thank you. And lastly, when the case in these proceedings was pleaded, you would have been shown the draft of the pleadings, wouldn't you? Can we look at A6? See their reference in paragraph 12 and paragraph 13. The text crossed out in red referred to the end of the term of the agreement as being the 24th of May 2019, termination date. So the original drafting of this pleading assumed that the term started on the 24th of May 2015, didn't it?
Servicing, and that's when we started earning, we would have started earning the fees.
You didn't object to that pleading when it was initially issued? I have no further questions for this witness.
Thank you. Appreciate it. Mr. Smith.
Your Excellency, I've got no re-examination of the witness, so unless you have any questions for the witness, then
Yes, thank you for your time. Dismiss. For the second one.
Thank you. So I'll call Mr. Saliba, please.
Hello. I put it here. Roger Sariba, Vice President, Finance, GlobeMed Group. I swear by Almighty God to say nothing but the truth.
Have a seat.
Thank you. Mr. Saliba, you should have a witness statement in front of you. Do you have a copy of it? Pick up a copy. There's a hard copy in front of
This
you.
one, okay.
Yes, that's right. So if you turn to bundle, I think it might be tab 2, you should find your first witness statement. Do you see it there?
Okay.
Have it? It should be marked page 318 at the top right.
Okay.
Can you confirm that that is your first witness statement?
Yes.
And if you turn to the back of that statement, page 353, you confirm that that is your signature?
Definitely.
And can you confirm that the facts stated in that statement are true to the best of your knowledge and belief?
Definitely, yes.
Thank you. If you wait there, there'll be some questions.
Good afternoon, Mr. Saliba.
Thank you. Good afternoon.
Did you draft your own witness statement, Mr. Saliba?
Yes.
Can you turn to page D299?
Okay.
Paragraph 8. This is Ms. Atala's second witness statement. GlobeMed Limited is an investor and franchisor. Do you see that?
Yes.
Paragraph 9. GlobeMed Limited has various subsidiaries, franchisees, affiliates, and associated entities. Do you see that?
Yes.
I'll ask you to turn on 20 pages to page 319 in the same bundle. Paragraph 10, your witness statement, drafted by you. GlobeMed Limited is an investor and franchisor. On. Paragraph 11, GlobeMed Limited has various subsidiaries, franchisees, affiliates, and associated entities. A chunk of your witness statement is in identical terms to the statement of Ms. Atala.
Yes. Because these are the standard terms. For example, when we are describing the activity of GlobeMed Group, it's part of our...
There's a mantra, is there, of standard terms that you would both
Yes.
use? And
Yes.
they're identical to the word.
Yes, because when we describe the activity of GlobeMed Group, we have only one description for this activity. It's part of the object of GlobeMed Group.
You were CFO in GlobeMed between 2013 and 2017?
Yes.
Financial officer? You were working substantially on the finance side, right?
Definitely, yes.
Your background is in business administration,
Yes.
and you have a BBA degree from AUB.
Yes.
Between 2006 and 2013, you were working for Sodexo in Lebanon, is that right?
Yes.
Your responsibilities there involved HR, quality management, and IT.
No, my primary function was the finance manager. At Sodexo, we usually call it the FAD, the Finance and Administration Manager. and sometimes the HR goes under the administration and the IT function, because Sodexo is a service company, so the IT is not, it's a support function, it's not a primary function.
SPM, or the strategic partner model, is not a technical term of art in business administration.
No, it's a business model. It's a generic aspect of any business. When you have a strategic partner which covers all the fixed cost of a company, then you can go and seek additional business.
No academic writing in business administration that
I didn't encounter this terminology at school, at the university.
it's an internal label that's used within GLOBEMED. Is that?
It might be used in other companies. I see it as a generic terminology.
It's not used in any document in this case prior to these proceedings, is it?
As a terminology, no, but the concept was used mainly in the first communication between Mr. Khalma and Mr. Shofel. In the email that was sent by Mr. Shofel, he was counting on the synergy between the two companies to attract additional business.
Well, he was anticipating synergies, but he wasn't saying that you could leverage, or that GLOBEMED could leverage off the reputation of OIC in the UAE market, was he?
My understanding, it was.
There are occasions where, if it had been a concept, a current concept, one would expect to see it. So if one looks, for example, at 3884, at point 5 in this email from Mr. Tomi, which is copied to you. See that?
Yes.
There's reference to the various lost opportunities that are alleged. One, the first, is the reference to insurers who have terminated discussions. None have been identified, have they? Reference to a general loss of reputational enhancement pursuant to notification. And there's no mention there of the strategic partner model, is there?
I didn't get your point, sorry.
Well, if that had been at the forefront of your mind as a head of loss, one would expect you to have been raising it, or one would expect Mr. Tomi to have been discussing it with you at this point in October 2015. What is raised instead is the alleged loss opportunities with insurers who have terminated discussions.
Okay.
Is that all the strategic partner model captures?
I'm still not getting your point. So
okay, well, insofar as a complaint is being made as to the consequences of the notification, the withdrawal from the joint venture, there's no reference to a consequence that GLOBEMED is no longer able to leverage its relationship with OIC.
Yes.
You're describing your understanding, or sorry, Mr. Tomi is describing to you his understanding at the time. Right, isn't it?
What was the question? Sorry.
Well, he's describing his understanding at the time. He's describing it to you. There's no suggestion that you push back or you suggest that there's a further loss of opportunity by reference to the strategic partner model.
Mr. Tomi's email was after the termination of OIC contract, and he was describing the damage that was brought by this termination. And part of this damage was that some insurance companies, they opted not to work with GLOBEMED because OIC terminated
That's
this contract.
a bit of a spin, isn't it? What he says is they had terminated discussions.
Yes. And he is saying that lost opportunities with insurers who had terminated discussions as a result of the OIC arrangement. So what he is saying is that he had previous discussions with these companies.
GlobeMed entered a TPA with a Kuwaiti strategic partner, or it said that this was the case, in 2006. Is that right?
Yes.
And it entered an MOU to create GlobeMed Kuwait in 2010.
Yes.
You described that in your witness statement.
Yes.
At the time, you were in fact working for Sodexo in Lebanon, weren't you?
Yes, I wasn't working with GlobeMed.
And you were working in Sodexo until 2013.
Yes.
So you have no relevant knowledge of the use of the alleged strategic partner model in breaking into the Kuwaiti market.
Not that I am not aware of this. The strategic partner model was the result of this partnership with GIG in Kuwait. So even if I wasn't there at that time, but the result was there, and the impact of this strategic partnering was obvious.
Fair to say that GlobeMed has been successful in Kuwait, hasn't it?
Definitely, yes.
And as it's been successful, it has increased its number of clients in Kuwait.
Yes.
As it increases its number of clients, its first client provides a smaller proportion of its business.
Its first client, who is the strategic partner, when it was established, was the major client. He was providing, if I recall, around 92% of the business. And over the years, when other clients started to join, this client, the portion of this client started to diminish, and he represented around 20% in 2019.
I hope I'm being simpler than that. I'm just saying that as it developed more clients, the proportion of business of the first client diminished.
Not the proportion vis-à-vis of the full GlobeMed Kuwait portfolio, yes.
Would you accept that?
Yes.
So if we look at your table at D323,
okay.
so in the right-hand column, we see the number of clients increasing from 2 to 32.
Yes.
And as that occurs, we see the strategic partner business reduced from 92 to 22.
Yes.
That is entirely what one would expect without any reference to any strategic partner model, isn't it?
The strategic partner can be as extreme as this one, or can be less extreme. So sometimes we expect that the strategic partner remains at 20%, at 30%, but sometimes it can go beyond 20, below 20%. So there is no magic formula for the strategic partner. We cannot expect how much we can attract other clients or market share out of this strategic partnership. It's not a pharmaceutical formula that...
There's nothing to suggest...
Exact.
There's nothing to suggest that the GlobeMed would have failed in Kuwait without a strategic partner. There's nothing to suggest that that success is due to the particular reputation of the first client, is there?
What do you mean by your question? Is there nothing to suggest?
Well, all that happens is that as a percentage of business, the first client reduces from 92 to 22 as the number of clients increases. Is that so surprising? Is there any inherent necessity of the strategic strategic partner model?
It's a normal evolution of the business. Whenever, in any market, whenever you have this strategic partner providing you with this strategic mass of clients covering most of your fixed cost, then you are able to be more attractive, and you can attract more business easily.
I hear your assertion of that, but I don't get any of that on your table.
What do you mean you're not getting this in the table?
You simply have more clients And as you have more clients, the first client represents a smaller proportion of your overall business.
Yes, definitely. We have more clients, but we were able to attract these clients because we were able to have an economy of scale. We have, out of this strategic partnering model, when you have this strategic mass which covers all your fixed cost, you have a better, you can provide to the potential clients a better deal when you have all your costs that are covered. This is from one point. From the second point, when you approach other clients having a large portfolio already servicing, you can give them better negotiated rate with the providers, and they can expect more discounts from providers because out of this aggregation of business between them and other clients. So this is why it's easier to attract more clients once you have a growing portfolio. It's a snowball effect, if you want. It's the snowball effect that you can. The more that you have clients, the better you have tariffs with the providers, and the more you have discounts from the providers. And sometimes in some markets, you have small insurance companies, small to medium insurance companies. They will approach you when they see that you are servicing a large portfolio. They will approach you to service them because they will know ahead of time that they will benefit from the same rates that are being applied to large insurance companies.
I think we'll be a lot
Mr.
quick.
Saiba, thank you for you. I just would like you to advise you just to keep your answer very short, otherwise it will be
Okay.
clarifying the answer of the council.
Okay.
Appreciate your help to clarify the idea, but I think just short answer rather than too long, unless it's been asked by the
Yes,
council.
if we could avoid speeches and if we could avoid representations of your existing evidence, that would be.
Okay.
Could we look at D346, please?
Which paragraph?
Sorry, paragraph 99. Do you see your table there? Setting out the free zone company's financial results.
Okay.
And it started in 2009 with 11,000 lives. And as I understand it, there was a period of cooperation with Swiss Re until 2011. I appreciate you weren't there at the time, but you appear to be willing to discuss matters in Kuwait in this period. So I'm going to ask you about the UAE in the same period. And then after 2011, there is a substantial decline in the free zone entities business, down to 1,800 lives. So this company was failing, wasn't it?
For the same reason, the pull out of Swiss Re, they caused some of the clients to stop dealing with GLOBEMED, and for the same reason that GLOBEMED didn't succeed in the Dubai market, because the GLOBEMED business model is based on exclusivity, and this exclusivity was not enforceable in Dubai.
And that's why the business model failed in Dubai.
Yes, this is one of the major reasons.
There was a degree of skepticism from some on the OIC side as to whether the joint venture would provide any real benefit, because they already had a big network. That's right.
They had what?
They already had a substantial network, didn't they? They had hundreds of thousands of lives.
They had a network, yes, definitely.
Well, they had two things. They had hundreds of thousands of lives, and they also had a very substantial network of providers, didn't they?
They had their network, Definitely, yes, they had their network.
For example, if one looks at F1 1977, there's been some discussion. This is December 2014. This is you to Ms. Fuddle, essentially.
Yes.
And there's been some discussion of whether there should be payment for your network. As for the network, it was previously agreed upon that you will not pay for it for the same reasons you mentioned above. And apart from the network by itself, GlobeMed Gulf value is the economy of experience that was acquired over the last years, in addition to all the efforts spent on the compliance to the regulatory requirements as described in the attached documents.
Okay.
So you are essentially saying that insofar as there's some form of network cost, that covers the economy of experience in dealing with regulators in the UAE. Is that a fair summary?
Yes.
And ultimately, it was agreed there should be no charge for goodwill. Now, in terms of the negotiation of the TPA, we look at D324, paragraph 24. Reference to you being involved with the negotiation of the TPA agreement and the MOU. You were focused on the financial arrangements. Is that right?
Yes.
Travelled to Dubai in October 2014, and you were dealing with OIC's due diligence. You were presumably providing the financial information and documents they required.
Usually I don't. I was there, but I didn't provide personally. The due diligence was a request by OIC, so they had a list of items that they wanted to check. The local team prepared this item, and I joined them during the time to be present in this exercise.
You say you recall GMGHS entering a strategic partnership. There's no mention in any of the relevant documents at the time, is there, of a strategic partnership?
Any joint venture, it's a strategic partnership. It's not.
No mention in any board paper or board minutes or any GlobeMed internal document. There's no reference to any strategic partnership, is there?
I cannot recall if it is mentioned or it is not mentioned, but the term strategic partnership or strategic mass is commonly used in GlobeMed. So, in any feasibility study, we use the term strategic partner or strategic mass. And in some of our MOU now, I recall that we always put a clause referring to the strategic partner, and we always once we incorporate any company or we have MOU with another party, we always keep a clause that in case we identify a strategic partner, that all parties will include the strategic partner in the partnership and agrees to give him part of their shares. So the term strategic partner is commonly used in GlobeMed and in some of the documents.
For those of us who have spent a number of days, even weeks, poring through these documents, the first reference to strategic partnership, email of Mr. Tomey of the 20th of July 2015, at 3871. Only in July 2015, after the withdrawal, the notification, and if you look in the middle paragraph, there are A, B, C, D in bold. D suggests a loss of opportunity with other potential clients or strategic partnership agreements.
Okay.
Now, you are copied into some of the emails dealing with the drafting of the legal documents. All that?
Yes.
Look at 1974. This is the drafting of the exclusivity provision in the TPA. Do you recall this? It was an email that was copied to you.
I don't, now that I'm seeing it, yes, but I don't recall everything, all the document, but since I was copy on it, so I must recall it.
If you look at the last sentence of the draft, this exception in all cases, all times, to be subject to a total number of individuals not exceeding 50,000 members. So that's the exception to the exclusivity obligation, isn't it? That?
Exception in all cases, subject to the, yes.
You don't object or protest at the inclusion of that provision, do you?
No, not at all. This provision was even a part in the TPA agreement, and it was subject to a certain mechanism, so that the TPA will be given the chance to talk to the client and to try to get this client on board. And as a last resort, the TPA will give the flexibility to the client not to be serviced by GLOBEMED.
Were you party to the negotiations of that provision?
At this point, I might be, I might not be, I cannot recall.
If we look quickly at 1983, see some background from Mr. Khalifa and reference to the fact there are two other TPAs in addition to GM that were being held in the wings. Were you aware of those other TPAs that were being considered by Mr. Khalifa?
I don't remember that they have other TPAs on board, but when I have seen these documents, so now I'm aware that, but I wasn't fully aware.
When the 50,000 exception was being discussed, was there any reference to other TPAs being, specific TPAs being used?
Not in front of me. It was in general and not a specific, for a specific TPA. Usually it was the intention behind this, this exclusion. Sometimes some clients, they request a specific TPA. This is why the clients always take this exclusivity, not to lose a client due to the TPA.
Exceptions from exclusivity, or limited exceptions from exclusivity are normal.
Yes.
Now, in paragraph 30 of your statement at page 325, you say, I have been, do you have that? Say, I have been shown an email dated 9th October 2014 from Mr. Schoffel of OIC to Mr. Karma. I don't think that email was even copied to you, was it?
No.
When you say I've been shown, who showed you that email?
When we started the negotiations, and I was involved with this negotiation, so I had access to this correspondence.
So who do you think showed it to you during the course of negotiations? Said someone showed it to you in the course.
I don't recall if it was forwarded to me or if I had access to it under a shared folder or something. I cannot recall.
The formulation "I have been shown" suggests you've recently been shown, doesn't it?
No, not really.
Doesn't represent reality. So.
No, not really.
We look at paragraph 32, as referenced there to Mr. Tomey. If you look at the second sentence, I was aware at the time of entering into the agreement that Mr. Tomey was responsible for seeking to identify other potential TPA client business. No suggestion that he found any other TPA client business, is there?
Yes, definitely. It was Mr. Tami was managing GMGHS, and part of his duties was to identify clients.
But GMGHS had no exclusivity obligation itself. It could, in theory, have offered TPA services to other insurers, couldn't it?
Yes, OIC had the exclusivity towards GMGHS, but GMGHS was supposed to service OIC and other clients.
And Mr. Tomey, who we have seen to be a very capable individual, was unable to find any other potential TPA client business, wasn't he?
He didn't succeed at that time to bring in new business.
And there's discussion of the financial projections in the MOU. Were you responsible for those projections?
It was prepared by Eli Tame. He was the general manager of the operation, and I was reviewing this projection with him. And same as OIC Finance PP PJ.
Can I just ask, did he report to you in formal management terms?
Mr. Tami, no, he doesn't report to me. My position as CFO or VP Finance at the level of the group, I have a visibility over the financial activity of all our subsidiaries. I receive reports, financial reports on monthly basis, quarterly basis from our subsidiaries, but they don't report to me. Each operation, they have their independence, they have their finance people, finance manager, general manager.
Can I just ask you about Annex 2, which I think you've reviewed? Behind those numbers, which is the P&L essentially for years 1, 2, and 3 of the term, there was an Excel spreadsheet. All that?
Yes, so it was the working sheet.
And as an Excel working sheet, it had a number of pages, didn't it?
Number of tabs, you mean?
So there were tabs along the bottom, and if you clicked on the relevant tabs, it brought up essentially a new sheet.
Yes.
And you say in paragraph 34, if I could just take you to the top of page 327 in D. That Annex 2 was to, and I pick up at the second line, top of page 327, illustrate how revenue would flow into and out of GMGHS pursuant to various contractual agreements. Right, isn't it?
Excuse me, which paragraph?
Sorry, the top of page 327 in bundle D, paragraph 34.
Okay.
See that? So you're discussing Annex 2, the P&L for years 1 to 3 of the term. And then over page, top of page 327, it was to illustrate how revenue would flow into and out of GMGHS pursuant to the various contractual agreements.
Yes.
Essentially, the TPA determines the flow of revenue into GMGHS. Is that fair?
TPA, no, you meant the P&L, the P&L projections.
Well, insofar as services were provided to OIC under the TPA, fees would be paid under the fee structure and would be paid into GMGHS. That's
yes.
Fair. And then
fees, this P&L projection included fees from OIC and fees from other than OIC business. And it included also revenues from providers as administration fees, and included volume rebates from providers also.
I'm going to look at the outflows. You've described the inflows, but yes. The outflows would be, and you've said pursuant to the various contractual agreements, that would presumably be the MOU, wouldn't it? Because that had determined the shareholding structure of GMGHS.
No, the outflows were the actual cost and the expenses that this TPA will be incurring to perform its business. Mainly under the TPA, you have the main expense is the payroll cost, the HR cost, Then you have the other operating costs.
I don't think we need a complete summary of all the operating costs, but just for clarity, when you say would flow into and out of GMGHS,
Okay.
you say out of refers to cost.
Yes.
That's not the outflow of profit to the shareholders of GMGHS.
No. Sorry. No, here when we say out of GMGHS, we mean the expenses that are related to this TPA.
We look at paragraph 41 of your statement.
Yes.
You say that in support of that position, I understand OIC sought to provide assurance to BUPA, its own client, GMGHS would be able to replicate the improved results across healthcare providers. Now, when you say your understanding, what do you mean by that? Is that based on emails that have been shown to you?
No, I cannot say that this is based on email, but it was based on discussion, because when we performed the proof of concept for OIC, and the result of the proof of concept was mainly positive for OIC. As a result of the proof of concept, we showed OIC that we made 17% savings for them, which was an improvement on their own savings by 12.5%. So we understood from them that they wanted to give the same assurance to BUPA that they will benefit from this improvement in claims adjudication.
You reference, in support of your understanding, an email of the 28th of January 2015, which is at 2295. See that?
Okay.
Now that document wasn't sent to you, was it? It's from Dr. Panda to Mr. Nawar.
Was sent to Mr. Nawar, yes.
So how was your understanding based on that document?
This document I wasn't on copy of this document.
So how is it that you base your understanding on that document?
I didn't say that I based my understanding on this document.
Okay, could we go back to your witness statement, page 327? So, paragraph 41, I understand that OIC sought to provide assurance to BUPA. The end of that sentence, colon, and then over page 328, you reference this email.
Okay.
Another email you have been shown?
This email was shared with us when we received the document disclosure from OIC.
So this is a comment on the document disclosure in this case.
Assume this.
Your evidence. You can't assume that your understanding is based on the facts. You must know why you're referring or referencing that document as supporting your understanding.
I assume this is based on this email and other discussion, so it's I cannot say that it was only based on this email.
Suggest to you that all you're really doing is making submissions or arguments based on emails you've been shown.
Yes.
Could you look at paragraph 46 your statement? And you're saying, you say halfway down the paragraph, it was agreed and understood that the agreement would be effective immediately upon signature.
Yes.
Was it agreed? Just understood.
It was agreed.
And you don't give any detail in respect to the alleged agreement, do you?
I confirmed this in my response to Hajar when Mrs. Atalla asked her to include the date, the contract, and Mrs. Hajar replied by that this was subject to BUPA agreement. I immediately responded to her and confirmed that we agreed to that this was the confirmed date of the contract.
What agreement were you referring to?
The agreement, the agreement that we have signed on the January 13 of 2015.
That agreement doesn't spell out or provide that it commences upon signature, does it?
Any agreement is effective on its date of signature. It doesn't spell out that this agreement will be postponed to other date.
But accept that the parties signed the agreement without having included a start date, wouldn't you?
Yes.
That would be an extraordinary inadvertence or mistake or error by both parties, wouldn't it?
I don't think so, because all our agreement, we don't put a start date for the agreement. Once we sign the agreement, we consider that this agreement is effective.
I suggest to you there was no agreement to that effect by the parties in the TPA agreement.
No, this is completely wrong. I don't agree with you. There was a signed agreement, effective agreement. This agreement has been, we started to implement this agreement till the 2 days before the launch date of the starting providing the service. But in order to provide the service, there was a lot of preparation.
We look at 2124, please. And do we need to pause for the transcriber?
No, carry on. I just want to check my battery. Yes, we'll break at 3:30. Sorry for that. Just cannot.
Will we break until 3:30, my lord, with that?
Break at 3:30.
We'll break at 3:30, thank you.
Cannot follow that. Problem with the laptop. But carry on, please.
So this, starting the chain at the bottom of the page, you've got Ms. Fadl's email. He's saying we added the BUPA clause with a 1-month period to get approval from BUPA. The agreement can only be effective from the date the approval is obtained. So she expresses a pretty clear opinion that there was no agreement that the TPA would be effective or commence on signature. That's her view, isn't it?
That was her view that she expressed in this email. This is why I found the need to reply to her to correct the view and to remind her that what we discussed during our meeting before the signature was that we had an agreement, and the major concern of having an agreement or not having an agreement was the mobilization plans, because we were, I think, I can talk of ourselves, and I'm sure that OIC people, we all had concerns about mobilization plans, so we didn't want to postpone the mobilization plan. And if we don't have an agreement, we cannot start the mobilization plan. So any mobilization plan will be...
She's not proposing that you suspend mobilization. You don't need to suspend mobilization because you've got the BUPA clause, which means that you continue to mobilize, but if in a month's time they haven't got BUPA approval, there can be a renegotiation of the fee structure.
I cannot start mobilization if I don't have an agreement. We never start mobilization before having an agreement.
That's what the BUPA clause provides, isn't it?
The BUPA clause is an exclusion to the exclusivity clause, but we cannot start mobilizing for any contract if we don't have a firm signed agreement.
In any event, you have a...
This is why I'm linking the two. This is why I introduced the mobilization plan here. So I made the point to Hajar in this email that we cannot wait for the BUPA clause. This will delay our mobilization plans.
Well, you're objecting to the BUPA clause. The BUPA clause is already in the MOU, isn't it?
Yes.
It's a specific fix to a particular problem, which is the concern on the part of OIC that they wouldn't get BUPA approval.
Yes, because in the MOU, they committed for exclusivity, but at the same time, they didn't get the BUPA approval. So they choose to put this BUPA clause because I cannot commit for exclusivity if I cannot deliver this exclusivity. This is why they opted to put this BUPA clause.
Their problem is they're worried about BUPA and approval. Your problem is you want to mobilize. And the BUPA clause resolves those issues by allowing mobilization pending the obtaining of BUPA approval. That's what the BUPA clause is doing, isn't it?
No, this is not the case. The BUPA clause only just to accommodate for OIC to commit for this exclusivity. So they committed for the exclusivity, but they didn't have the approval from BUPA at that time. So if I were in their shoes, I would also have put the same clause. I need to get the green light from BUPA to provide you to commit with what I already committed by exclusivity, not linked to any suspension of the contract.
Now, you suggest in your statement that Ms. Fadl failed to respond to your email. That's wrong if one looks at 2126. She did respond. She'd already stated, sorry, go back to 2124 is probably better. Go back.
She didn't respond. She didn't respond to the specific fact that I was confirming that we had an agreement, but definitely there was a continuous correspondence, and her response in this document, she was taking our approval to share some material with BUPA. So it wasn't a direct, it was part of the chain of correspondence that we had at that time, but this is under a different topic.
Essentially, her response was one of pragmatism, wasn't it? You had a difference of opinion, which was clear, and the whole issue of conditionality or commencement could be avoided if BUPA gave its approval. She was proposing, and you see the top email of this page, that you proceed to get the approval from BUPA. That's the pragmatic response, isn't it? He's getting on with it.
Sorry, excuse me, I didn't get your point in this specific.
Well, rather than continue a sterile argument as to your difference of opinion, which has already emerged in the previous emails, rather than simply continuing a back and forth, a pragmatic solution is that she should make strenuous efforts to get the approval of BUPA, because that resolves the problem, that avoids the problem.
It should be. I didn't take it from this point of view, but it is as if she said, okay, yes, let's proceed with the due diligence exercise.
And
She didn't insist on her point. I didn't see any insistence on her point.
She then seeks to drive forward the process of due diligence until her email of the 11th of February, which we have at 2542.
Okay.
Email, and she's telling you that for 3 weeks the teams have been hard at work, but BUPA has not yet made a go, no-go decision. Says at this point, we see no need to reopen any discussion on the MOU in terms of Section 15. Clearly, she thinks there is an issue. They may need to exercise their Section 15, their Article 15 rights, reserves their ability to do so by saying at this point she doesn't need to.
Yes.
We accepted that was her position.
Message is very clear.
Now, in the transition process, it's essentially the TPA that provides information in respect of its systems, isn't it?
The TPA
needs to provide information in respect of its systems. So as part of the due diligence,
okay,
TPA provides information about its systems.
About the systems? Yes.
And the client will need to provide information in respect of their customers.
Definitely, they provide information about their customers. Sometimes they provide confidential medical information. They provide details of their premiums and all the conditions that will be input on the TPA system, so the TPA will be able to manage these portfolios.
Generally speaking, you're barely involved in this process of transition. You're hardly copied into any emails.
Yes, because as far as I'm concerned, at the level of the financial performance of the operation, but I'm not really involved in the operational performance of the TPA, unless there is a problem which will impact the financials or the profitability of the subsidiary.
You are copied into some emails about the announcement of the venture. I think if we look at 2877 in F2.
Okay.
So this is copied to you, and it's a concern being expressed by Maître Atalla to the effect that it may not be in the best interests of GLOBEMED Gulf's business for OIC's interest to be public, because it may stop, or it will stop, other insurance companies from signing in as clients afraid from OIC's access to its data. So you were at the time of that concern being expressed on the part of OIC.
There is always this concern. This is why we inform our client that there is a kind of Chinese walls for the data between the clients by themselves, and if in the case where the client is at the same time a shareholder, this specific shareholder doesn't have access to specific commercial or medical information to other clients. And this is part of the understanding and undertakings that this shareholder would take. And this is one of the reasons why in most of the territories we have a shareholder that is at the same time a client, and we have other clients. And this is in more than one territories.
But it does seem to be acknowledged by Mr. Tuller that that is a problem with what you're now calling the strategic partner model.
No, it's not a problem. It's a problem that we treat. It's a one of the apprehension, but we find the solution for this problem by creating the Chinese walls and preventing the shareholder of accessing sensitive commercial data to of other clients.
Well, the solution that's being proposed here is that OIC's involvement should not be disclosed, isn't it? That it should be made clear that Synergize is the new shareholder.
Which was the case.
In March 2015, you attended a meeting in Dubai about the financials. Do you recall that?
At that time, we attended a lot of meetings, several meetings, so I don't... I must have attended, or I might have attended, so I don't recall the full timeline. We were going on several rounds of meeting and reviews at that time.
We look at 2914. This is from a meeting March 2015. The BUPA issue is still very much alive, isn't it? It hasn't been resolved by this point.
Excuse me, but there is a problem with this. Which section of this?
Sorry, the BUPA, if you look at the left-hand column,
the
BUPA issue. Do you want to refresh your memory? So there's a concern about whether BUPA, or the fact that BUPA are still negotiating, and what is in prospect is a delayed transition for BUPA at this stage 3 months after the launch date.
Yes, as from the initial, from the beginning of the negotiations with OIC, there was always the plans to have a gradual move or transfer of OIC portfolio from internal being serviced internally by OIC to being serviced by the TPA. So any delay in BUPA decision will not affect the transition plan, because they suggested that they will start with their own portfolio, and their own portfolio was substantially as big, much bigger than BUPA portfolio do. So in performing the transition plan, they can easily put the leave the BUPA portfolio till further stages.
Before we leave this document, can I just ask what you meant by a soft launch in April, which you appear to be suggesting at this point?
I meant by soft launch to start transferring a limited number of insured members. So this will help both entities synergize between themselves and identify any transfer problem or any integration problem that will not affect the major transfer of business that will come. So it was.
Is that because the soft launch would encourage or reassure BUPA?
It wasn't specifically designated for BUPA. It was to put at ease all parties that there will be no problem in the transfer of the business, because we focus a lot on BUPA, but also OIC, they had a lot of concern for their portfolio. So neither us nor OIC people didn't want to put at risk the customer experience.
And that suggestion of a soft launch in April wasn't accepted by anyone else, was it?
I don't think so, because there was no transfer of any members at that time.
Break now for 10 minutes, come back.
Thank you, Mr. Saliba. I just raise one issue which is causing concern to my learned junior. Referred to Annex 2 as including both OIC profits and non-OIC profits. Right?
Yes, it includes revenues from OIC and non-OIC, revenues that might lead to profits.
We could turn up page 2108. This is the net income from the projected, I should say, net income from the 3 years in Annex 2. Your projection for the net income was essentially $3.3 million in year 2 and $5 million in year 3. So that's total profits, you say, OIC and non-OIC of $8.3 million. Is that right?
Yes, for the first 3 years.
Both OIC and non-OIC?
Yes.
There were also concerns at the time about the willingness of existing providers to work with GLOBEMED, weren't there?
There was concern of existing providers not accepting to move the transfer from OIC to GLOBEMED, and they put some conditions. Some of the providers' conditions was that they requested OIC to settle all their pending claims before accepting the transfer between OIC and GLOBEMED. And some of the providers, they had some complaint about GLOBEMED, same like the one that we were discussing before, which was Mediclinic.
They wanted to leave the GLOBEMED network because of non-payment, didn't they?
They expressed their request to leave GLOBEMED, but this relationship between TPA and the provider is a normal situation, and it's a continuous struggle between the two, either TPA or the insurance company, between any payer and any supplier. Sometimes they don't agree on the terms. Sometimes they want to have a better negotiation terms, and during any change, they take the advantage to have a better conditions. So this notification from Mediclinic that they stop accepting GLOBEMED is a normal situation, and usually the TPA and the provider ultimately, because they both need the business together, they will sit and they will agree. Sometimes there are 1 month's interruption, 2 months interruption, but ultimately all the providers, they like to work with all TPAs, and all TPAs, they want to work with all providers.
The particular problem was that BUPA wanted to ensure that there was continuity of service. They wanted to ensure that the providers being used for their clients would still be available for their clients even after the transition.
Definitely, it's a very normal reaction and very normal position from any insurer.
So if, for example, American Hospital decided it wouldn't deal with GLOBEMED, that would be a real problem in terms of BUPA, wouldn't it?
Yes, definitely. But I can assure that this would not happen, because any provider and any TPA will ultimately agree on the terms, and they continue their cooperation.
We look quickly at 3043. Now this is Mr. Tomey's attempt to reassure Dr. Panda and he says, referring to Mediclinic, this is the largest provider group in the network, so real problem. He says there are always items of one sort or another that need working on. This is an ongoing process. As I'm sure you've experienced yourself, it is the providers that are intractable. So yes. It isn't going to be resolved.
This is typically what I was trying to say.
And Dr. Panda says he's, second paragraph, spoken to Mediclinic and we're working on resolving this. So it's OIC that's seeking to resolve this particular issue. And then he explains in the third paragraph, however, this should in no way impact on OIC since you continue to use your contract. Moreover, the situation is entirely different since unlike other payers, we will be controlling the claim funds and therefore no similar issues arise for OIC. In addition, please do not allow Mediclinic to conflate any issues with other payers with OIC's contracts. This would be entirely wrong. So he's essentially saying, well, this may be a problem for GMGHS, but it won't be a problem because the service will be being provided to OIC by the providers, not to GMGHS. Is that his explanation?
No, what Eli is saying here in this email, that what I was saying before is that this situation and this relationship between a specific provider and the TPA or insurer is a normal process. We have this problem. You, OIC, you might have encountered this problem, but he is assuring that the problem with OIC will not be the same, will not arise, because as part of the TPA agreement, we were supposed to have a fund from OIC to pay the claim. So there will be no delay from the insurer once the claim is adjudicated. So, and this is one of the major issues and conflict between a TPA and the provider.
Were you aware of other refusing providers?
As I have said before, I'm not following on the daily operation, so I don't recall any instance. Also, there might have been some.
Yes, if you look at 3129. We see an email from Dr. Panda to Mr. Tomey, copied to you, referring to a circular to be released to providers to resolve provider apprehensions. So you were aware that there was a wider problem of provider apprehensions.
There was an apprehension, but I wasn't aware that it was wide, and I don't think that it was wide. I think that at one time they reached around 92% of providers confirming that they will join this transfer. They will accept this transfer of OIC contract from OIC to GLOBEMED.
If we look at 3346. Either an email from, I think, Dr. Panda to L.L.C, Tomey, thank you, the 15th of April. So this is mid-April. This is quite late in the transition process. And we see the PS at the bottom that Dr. Panda will engage personally with both Mediclinic and American to make sure they get on board. And the rest, I believe, GLOBEMED will be able to take care unless you specifically ask me to get involved.
Okay.
So there was particular concerns about Mediclinic and American Hospital, but there were clearly others as well, weren't there?
Yes, when you have, in all territories, you have preferred providers. You have major providers that any insurance company would like to have in the network, and that they cannot afford not having in the network. So, and this was part of the cooperation between GLOBEMED and OIC. So whenever GLOBEMED had a problem that OIC could have solved, they would do it.
And because these issues were being dealt with by the operations teams, generally speaking, the progress status reports and the task lists were not sent or copied to you, were they?
No, not all the time.
Could look at paragraph 58, your statement, page 332. Now here you refer to various emails. So if we look at 58A, just from your statement, that's an email from OIC Ms. Fadl to OIC Mr. Yasser. That's an internal OIC email, isn't it?
Yes.
And then if we look on at paragraph 59, little A, reference to an email from OIC Gramas to OIC Mr. Khalifa. That's an internal OIC email, isn't it?
Okay.
Go down to C, I'd make the same observation. OIC to OIC. If we look at paragraph 60, that's the witness statement, updated draft plan that I understand was circulated during the transition period, and you reference an email again, OIC to OIC.
Okay.
These are email exchanges in February to May 2015. None of these emails were sent by or to you, were they?
Don't think so.
These are emails that have been shown to you in the course of these proceedings, aren't they?
If it is there, yes.
The court would do better, frankly, just to read the emails, wouldn't it?
Excuse me?
Well, rather than take your selective quotations of these emails, the court would do better to read the emails, wouldn't it?
I don't understand your question.
Sounds like a
I'll withdraw the
submission
question.
anyway.
I don't need to take it. You don't. Perhaps we can make some progress. We agree that the transition period was lengthy and uncertain, wasn't it?
Cannot say that it was, I assume it was more than previously expected.
If you were doing a TPA, for example, for a Lebanese insurer, you would expect the transition to be relatively quick, wouldn't you?
I cannot assume. It depends the size of the TPA, of the insurance company, and the system that they are using.
You need to integrate the systems, you need to obtain regulatory permits, you need to bring BUPA on board, you need to get the approval of the providers. There's a lot of work to be done in the heavy lifting of this transition.
Definitely, yes.
Insofar as there's a contract period, whether 3 or 4 years, you wouldn't want it to start until the launch, would you?
We wouldn't what?
Want the contract period or the contract term to start until the launch, would you?
The contract started in January 13, but the service will start on the launch date.
You would say that on that basis, the contract term would have ended in January 2019.
20 will end. Yes.
The issue really is whether the parties were bound before all the transition works were done, isn't it?
Excuse me?
We look at 65, sorry, paragraph 65 in your statement. You say there, when I was preparing this witness statement, I've been provided with a copy of an email. Do you see that?
Yes,
That's an email to OIC, isn't it?
yes.
Didn't see this email at the time, did you?
At the time, you mean in 2015?
Yes.
No, I didn't see this email.
And in paragraph 66, you refer to another email from OIC to OIC. You didn't see that at the time either, did you?
No.
Paragraph 67, you refer to another email, 8th of May 2015, OIC to OIC. Didn't see that at the time, did you?
No.
Paragraph 68, an email from BUPA to OIC, 14th of May. You didn't see that at the time either, did you?
Yes.
We look at it. 3665. This is an email from Sama Sawaya of BUPA to Ms. Fadl. Not copied to you, it's not sent to you. You didn't see it, did you?
No, I didn't see it, yes.
These are all emails you've subsequently been shown.
Yes.
You haven't been shown emails reflecting OIC's frustration with the repeated rounds of BUPA due diligence, have you?
OIC frustration with the repeated rounds. I don't recall this.
You haven't been shown OIC internal emails reflecting concerns about OIC's margin if BUPA delayed transfer, have you?
Yes, I have seen this. I have concerns if BUPA will, or the transfer of BUPA will be delayed, they will be incurring additional cost.
You haven't exhibited or referred or referenced those emails in your statement. They haven't been shown to you for the purposes of this.
I didn't find any reason to include them in my statement. I had access to these emails as part of the exchange of documentation when
They weren't shown to you.
I had access to all the disclosed documents, so either during our preparation with the legal counsel or internal review, I had access to this information.
Now, after notification, you allege that notification caused significant reputational damage within the market.
Yes.
Yes, that GMGHS has been unable to grow its business in the UAE thereafter.
Yes.
You have no basis for speculating that that's the cause of GM's continuing failure in this market, do you?
We spent, after the termination of OIC contract, we spent more than months and months approaching client, but unsuccessfully without getting any business.
And the suggestion is that if you'd had OIC as a strategic partner, magically all of these other insurers would have been flocking to sign you up as a TPA.
They're magically, I don't see it's magically, but they will ultimately, GMGHS will enjoy a better position in the market, will enjoy a better tariff with the providers, which will lead to attract new clients.
Could I just ask you about that? GMGHS has almost no existing lives. It has 1,800 at the time of this venture, 2015. Right, isn't it?
1,800.
800 lives. That's its pre-OIC OIC portfolio of lives?
Yes.
If and insofar as this DPA had been pursued, in effect, GMGHS would have had no more lives than OIC already had. All you'd have had is the OIC lives.
Yes. Yes.
You were not bringing a substantial TPA portfolio to add to the OIC lives, were you?
It was the plan in the first year that GMGHS will focus on the transition plan. Since we were transferring around 400,000 lives, we were supposed to transfer around 400 lives from OIC to GMGHS, so we couldn't have afforded in the first year to approach a new client or transfer a new client. This is why in the projections, in the first year, we didn't project for any non-OIC lives. So the plans was that once we will finish the transition from OIC lives, we will start approaching new clients.
But you would have been in no better position than OIC, would you? You would have had the same number of lives as OIC already had.
In the year one, yes.
What's the basis for your belief that you would have increased revenues, or you would have been in any better position, for example, in negotiating with providers, than OIC already was by reason of its existing number of lives?
But OIC is not a TPA. OIC is an insurance company. So as a TPA, it's a different business model. So OIC will not act. OIC is an insurance company. They will attract insured person, whereas the TPA will go to the insurance company and will propose to them to manage their claims, their medical claims portfolio. So it's not the same business model.
Just as I understand the business model, the idea is as a TPA, you bring a larger portfolio of lives.
Yes.
Therefore, you're in a better position than a single insurer to negotiate with providers. That's part of the strategic partner model, isn't it?
As a TPA, once you have a large portfolio, you can get a better discount, a better tariff from the providers, and these better tariffs, the provider will attract other clients, definitely.
But here you don't have that advantage.
As the first year, yes. The first year we don't have. This is why we were supposed to start enrolling new clients in the second year.
As for the reason why GMGHS has failed to grow its business in the UAE, you have no basis for speculating that this is the cause, is the withdrawal of OIC, do you? No relevant correspondence from any other insurer or any potential client, is there?
Definitely no. The client will not tell you, because OIC terminated their contract, we will not work with you. They will not say this. They will not send this by email. But
Saying they won't say it at all, or they just won't put it in an email?
no, they will not. They will not say. They will not tell you this. But
There's no
your reputation in the market will get a hit. But you will not find someone who will tell you that since OIC terminated with you, I will not work with you.
It's an intangible something in the air. You sense your reputation has been damaged, and that is why no other insurer has wanted to engage you.
Yes, it's intangible. It's sometimes it's hinted, but it's not bluntly said.
We haven't seen any correspondence that hints at it, have we?
No.
There's been no adverse comment in any trade press or regional media?
I don't recall this.
Your evidence is that you were seen an email, or you've been shown an email from Mr. Karma to Mr. Schoffel. I think that's at 3783. Do We look at, if we see the paragraph at the bottom of the page, we shall be liaising with you to discuss and understand the rationale behind this abrupt decision, which carries serious implications and heavy harm on GLOBEMED healthcare solutions at all levels, material and moral, and particularly on its goodwill, which we trust you will acknowledge. Now, that's not evidence, is it? That's a self-serving complaint by Mr. Karma about reputational damage, isn't it?
Yes.
And insofar as Mr. Tomey at 3871 refers to long-term harm, that again is simply a complaint, it's not evidence.
Yes, definitely.
Now, in terms of informing DHA and providers, if we look at 3789, Mr. Khatib refers to a meeting to discuss wording to be provided to the DHA. That was copied to Ms. Atala, but it wasn't copied to you, was it?
No, because this relates to a regulatory issue. I don't think that I was supposed to be copied on this email.
And it's I think if we go up the chain, Mr. Khatib on the 8th of June says we are sending the note to DHA today. Ms. Atala at the top of the page, second paragraph, says we request you not to release anything. That's the 8th of June, so the same day. And obviously Mr. Al-Khatib is pressing for comment, and if we go up the chain again.
Yes.
Mr. Go up the chain. Oh, sorry. It is said in your statement that OIC agreed and implied that they failed to seek GLOBEMED's approval of draft messages. That's not true, is it? They were, in fact, actively seeking your agreement and approval of draft messages, weren't they?
Yes, but this was not granted. This approval was not granted. And as demonstrated here by Mrs. Atala email.
They were seeking that approval, weren't they?
They were exchanging this draft with GLOBEMED.
There were various meetings at the time between the parties. A meeting between Monsieur Fahan, Mr. Karma, and Abdulaziz Al-Ghourer.
Yes, I was.
You weren't present at that meeting?
I wasn't present, but I was aware that this meeting was about to happen. I knew that it was going to happen.
Then if we look at D340, paragraph 75, So little a refers to a meeting at which you weren't present. That's right, isn't it?
Yes.
And then little b to e refer to various emails about various alternative propositions.
Yes.
So, for example, minutes of a meeting on the 14th of October attended by Mr. Tomi and Mr. Haidar. You weren't at that meeting, were you?
No.
A meeting of the 4th of November 2015 attended by Mr. Tomi and Mr. Haidar. You weren't at that meeting, were you?
No.
No evidence of no mention in these emails or in this paragraph of any economic concerns raised by Mr. Al-Ghurair in respect to the costs of parallel administration, is there?
In this specific email?
Yeah, well, in this paragraph, you're seeking to summarize, provide a record of these meetings.
No, in the email, in the reply, not the reply, in an email after the meeting between Mr. Faraon and Mr. Kharma and Mr. Al-Ghurair, so there was this exchange. There was an expression of concerns from OIC about the increased cost that they would be incurred. And at that time, an alternative solution to this situation was that GLOBEMED can propose to OIC an alternative proposal. One of these was the use of GLOBEMED systems, what we are calling here the unbundled service. So instead of giving a full bundle of TPA service, GLOBEMED would have provided OIC with part of its services, mainly the use of the system.
No record of a reference to GLOBEMED's success in winning the Ministry of Health as a client in these meetings?
I cannot say. I cannot recall this.
And in your record of these meetings, there's no mention of the strategic partner model, is there?
Term strategic partner?
Or the concept?
The concept, it's the generic concept of having one partner having a strategic mass of business.
You provide a brief record of these meetings but make no reference to the strategic partner model.
No, because this model is described in most of our proposals or in some of the MOUs when we always refer to having a strategic partner.
At some point, GLOBEMED started to scale back its operations, didn't it?
Yes, definitely, because we were, when OIC terminated their contract, we were still hoping that we could salvage the relationship between GLOBEMED and OIC. This is why we kept all the staff on board, and we were hoping still to get a non-OIC business or to attract business from non-OIC. But after a certain time, we found out that it was unfortunately a costly endeavor, and we were incurring high running cost at that time. So we took the decision to scale down our operation to the minimum.
You remember when you took that decision?
I think that we started the scaling down around beginning 2016, but I cannot confirm this because GLOBEMED Gulf was not the only operation that part of the GLOBEMED Group. GLOBEMED Group, we have at least 11 to 12 operations in several countries, so it's not the only it's not at least my only focus. So this is why I don't have the full details of the dates and.
You as the CFO would be looking at all of the subsidiaries across the group.
Yes.
And insofar as a subsidiary was not performing, you would be pretty quick to ensure that its activities were either turned around or scaled down.
We cannot say quick to scale down. It's not once we have a non-performing entity, we immediately scale down. The TPA business is a is a long-term business. So we always face having operation making losses, and we continue the operation because the TPA business is once you cover all your fixed costs, which are most of the time they represent a big amount, big portion of your cost, and you reach the break-even cost, any additional business will be highly profitable. So this is why the TPA business is most of the time loss-making during the first years of operation.
You think you may have hung on in the hope that you would get business and it would be extremely profitable?
We would hang on to get new business. Being extremely profitable, I cannot confirm that it can be extremely profitable.
Can we look at the 2016-2017 accounts at F34261? That's the P&L, isn't it, for 2017, GHS? Do you see that? So it was making, GMGHS was making losses in 2016 of 8.4 million dirham. Reduced slightly in 2017 to 7 million dirham.
Excuse me, this is not the document that...
4261?
Yes.
So 2017 were 2 years after the notification. Your GMGHS is essentially hanging on and incurring significant losses of 7 million dirham in that financial year. If we look at the 2019 accounts, they're at 4696. If we start with looking 2018, comparing 2018 and 2019, if you start with revenue, there's actually a significant improvement in revenue.
Yes.
The costs remain stubbornly high. Is that a fair summary?
In 2019, if I'm not mistaken, we got a contract from a client here. It's an unbundled service. It's not a full TPA service. This is what was reflected in the terms of revenues. And the cost, yes, the cost till now we are incurring cost in Dubai, the cost of maintaining an operation, even if you're not servicing, you will always have fixed cost.
And if one looks at the losses, again, the losses are increasing from 18 to 19 from 500,000 dirham to 1.2 million dirham.
Yes.
Again, this is a non-performing or a failing business, isn't it, Saliba?
Definitely, our operation in GMGHS is a non-profitable business. You can see, you're looking at the P&L, but you can see at the balance sheet the accumulated losses. It's quite an impressive amount of accumulated losses. It's around $10 to $12 million in accumulated losses.
GMGHS failed in the UAE market both before and after the attempted joint venture, didn't it?
Yes.
If the venture had proceeded, it would have had no more lives than OIC, would it?
The joint venture has proceeded. We would have, in addition to OIC lives, we would have attracted non-OIC lives.
It had no track record of success in the UAE?
Has no
track record
in UAE? No.
It had no particular familiarity with UAE insurers or providers or regulators, did it?
We approached many UAE insurance companies, but we were not able to get business, substantial business.
And the truth is that if the venture had proceeded, other insurers would quickly have realized that OIC was involved and had a stake in GMG.
I assume UAE market, in general, the insurance market is a small market, so definitely they would have known that OIC has joined.
Well, that may be a good moment to stop. I haven't finished, but I think it was envisaged on the timetable that I may not have finished.
We're going to continue with the witness next week? Or?
My Lord, yes, that is what's envisaged on the timetable.
Which is a agreed timetable, or this is
the PTR timetable, my Lord.
Yeah, well, Your Excellency, sorry to interrupt. Yeah, I mean, I sort of understood that my learned friend would time it so that he wouldn't leave Mr. Saliba in Purda over the entire weekend, which is not the way that one would normally approach these things. If my learned friend is going to be finished in the next half an hour or so, perhaps we could press on and get it finished. But otherwise, it's a bit unsatisfactory.
Lord, I'm not, and I specifically at the PTR warned of the risk of overrun. And in circumstances where cross-examining Mr. Tuller took quite some time for reasons that I think were evident, I'm not feeling too professionally guilty.
Yeah, we have agreed timetable, and I just want to see again our agreed timetable. Is it?
Can we give a page reference to the agreed? 1547. Sorry, 0. Just tell the judge.
On 5409.
95. And my Lord, I made pretty clear yesterday that I was entirely happy to be held to my undertaking that I would finish with Mr. Tuller by the end of today. It's regrettable, but...
Agreed then. So what's an issue, Mr. Smith? The agreed timetable to continue with Mr.
No, I'm not taking an issue. What I was suggesting was that if my learned friend could, if the court has time, and there's 35 minutes to go, then if we can go on till 5 and my learned friend can finish, then that would be much more satisfactory than leaving a witness in Purda over the weekend. But if he can't do that, then he can't do that.
But in this timetable, it's a Monday morning with.
Yes, but it says a risk of overrun, and that was negotiated and agreed, my Lord.
Is it agreed by Mr. Smith?
Yes.
Yes.
I'm just suggesting a pragmatic solution.
Well, yeah, but the problem with the pragmatic solution is I have more than 35 minutes, my Lord.
Oh, well, there we go.
No, that's fine. I mean, if we can finish, if you can finish by 5.
Well, my Lord, 5 is 35 minutes. I have more than 35 minutes of...
How long? 45 minutes?
Could be an hour and a half, my Lord.
Any objection, or shall we?
There's no objection to make. It's fine, of course.
Right. So, adjourn for next week then. Adjourn for the next week, and wish you a good weekend. All right. Thank you.
Thank you.
All right.
Nice.